Good morning, everyone. Welcome to the field hearing of the United States Senate Environment and Public Works Subcommittee on Clean Air, Climate, and Nuclear Safety. Today's hearing is entitled Issues Facing Communities with Decommissioning Nuclear Power Plants in the United States. First of all, I want to thank my ranking member, Senator Jim Inhofe, and the Committee on Environment and Public Works, Chairman Tom Copper, and Ranking Member Shelley Moore Capito for their support in holding this important field hearing. I'm grateful for their commitment to the important issue of nuclear plant decommissioning and for their innate understanding of the power of holding hearings where those affected by federal policy issues can attend and can take part. As chair of the subcommittee, I am grateful to welcome my friend Bill Keating, who is the congressman here from Plymouth and from the South Shore of Massachusetts. And of course, he is the congressman from America's hometown, Plymouth. And so we welcome Congressman Keating to our hearing. Senator Warren was not able to join us today. However, her staff, Hannah Benson and Liv Teixeira, are present, and Senator Warren will be submitting questions to the witnesses for the record. I want to extend my thanks to the town of Plymouth for hosting this field hearing today at the town hall in the 1820 courtroom. It is an historic room for an historic hearing. Thank you to the members of the Plymouth Select Board and Board of Health. Thank you to the Plymouth town staff for their work, including Town Manager Derek Brindisi and Assistant Town Manager Brad Brothers. Derek and Brad entered their roles just days before we told them we were bringing a Senate committee to Plymouth. So Derek, Brad, the entire Plymouth team jumped right into the planning and the preparations, and we thank them so much for all of their great work. Our deepest thanks to the entire team at Plymouth Area Community Access Television for their masterful preparation and tech work to ensure this hearing is accessible for those in both the real and the virtual worlds. In addition to State Senator Sue Moran, who is a witness on our second panel today, we are also being joined by the members of the Region's State Legislative Delegation, State Senator Patrick O'Connor, State Representatives Matt Muratori, Kathy Lanatra, Kip Diggs, and Steve Exaros are all here today, and we thank you all so much for your interest and concern about this very important issue. I also want to acknowledge the many members of the Nuclear Decommissioning Citizen Advisory panel attending today. Thank you to NDCAP for your work, for dedicating your time to this important issue of monitoring and advising on the decommissioning of the Pilgrim Nuclear Power Station. I also want to thank the many community groups who have for decades worked tirelessly to ensure the community's voice is heard and is listened to throughout the operation, the shutdown, and the decommissioning of the Pilgrim plant. This, of course, includes Mary and Jim Lampert from Pilgrim Watch and Diane Turco of Cape Downwinders. And I also understand that we're joined by leaders from the Duxbury Select Board, the Massachusetts Lobstermen's Association, and the Massachusetts Seafood Collaborative, and our local laborers, carpenters, and ironworker unions. And finally, I want to thank the members of the public who are attending the hearing in person, in the overflow room and on the live stream. Your concerns and participation is what makes the policy process work. For decades now, the people of Plymouth and the communities across the country have looked to the Nuclear Regulatory Commission to be the independent regulator of nuclear safety it was intended to be. However, in many instances, instead of fulfilling its responsibility to protect public health and safety, we find ourselves today with an agency that historically has consistently prioritized industry profits over public protection. Over the years, communities with decommissioning nuclear power plants have repeatedly called on the Commission to be a good regulator and for nuclear companies to be good neighbors. But those calls have gone unanswered. We have asked the Nuclear Regulatory Commission and the nuclear industry to listen to the residents near San Onofre nuclear generating station who worry about what an earthquake could do to the 3.6 million pounds of radioactive waste buried underneath that plant, which sits on an active earthquake fault line. We have asked them to listen to communities like Zion, which are struggling to overcome the social and economic burden of indefinitely hosting stranded nuclear waste in Illinois when there is no long-term storage solution in sight. We have simply asked them to listen to the people that have the most to lose and the least to gain from the decommissioning process. But time and time again, they have failed to do that. As the local residents at today's hearing remember well, in August of 2019, the Nuclear Regulatory Commission approved the transfer of the Pilgrim Nuclear Power Station license from Entergy Nuclear Operations Incorporated to Holtec International, a ruling made even before it resolved open petitions in the preceding docket or answered critical questions about safety, security, and funding. Keeping Holtec's business interest on schedule was a higher priority than answering public questions. And this blatant disregard for public input isn't unique to Pilgrim. We've seen it play out at other decommissioning power plants across the country. For example, in November of 2020, the Nuclear Regulatory Commission approved the transfer of the license for the Indian Point nuclear power plant in New York from Entergy to Holtec without even holding a single public hearing. This is unacceptable. Our communities deserve to have their concerns accounted for. We may not know exactly how nuclear power plants are put together, taken apart, but we know what it's like to live in fear of a nuclear disaster. We may not all be nuclear physicists, but we know what it feels like to breathe clean air and drink clean water. And we may not be accountants who've memorized every line item in a nuclear plant's budget, but we do know that when spent fuel is stranded at our nuclear plants for decades with no solution for long-term storage, someone is going to be left footing the bill. The families and the businesses and communities with decommissioning nuclear power plants do not all claim to be nuclear experts, but they do have honest and legitimate concerns about how a decommissioning nuclear power plant affects their health, their safety, their families, their livelihoods, their local economy. And it is well past time that the NRC and the nuclear industry take their input seriously. As Nuclear Regulatory Commission Chairman Hansen stated in a speech at the Regulatory Information Conference last year, public trust is essential for the future of nuclear power and use of nuclear materials. And to ensure the public trust, it is necessary that the government act as an independent, impartial regulator. Additionally, the public should be comfortable in trusting industry to deliver on its promise of developing and operating safe, reliable, and economic nuclear power plants and facilities. Well, I agree with what Chairman Hansen said about this process. And right now, that trust is hanging by a thread. And while I am deeply disappointed in the Nuclear Regulatory Commission and nuclear industry's failure to meaningfully listen and respond to the concerns of communities with decommissioning nuclear power plants, I did not convene this subcommittee hearing simply to pass blame and point fingers. Instead, I am hoping that this hearing will serve as an opportunity to identify real and meaningful actions that local communities, state governments, the Nuclear Regulatory Commission, and nuclear companies can take to create opportunities for public engagement. Communities around Pilgrim have a worthwhile story to tell about how the current process has failed them. We hope the Nuclear Regulatory Commission and other communities can benefit from this hard-won expertise. The proposed decommissioning rule that is currently open for public comment serves as a critical opportunity for the NRC to reassert itself as an independent, impartial regulator worthy of the public trust. Instead of simply approving this rule, which would allow the NRC and plant operators to cut corners on safety and limit public engagement at the expense of the communities near nuclear plants, I hope the NRC takes this opportunity to improve the rule. By putting a stronger rule in place, the NRC can ensure that communities have a seat at the table when it comes to the decommissioning process, better protect the safety and financial health of every community, and live up to Chairman Hansen's goals of securing the public trust. I look forward to hearing all of the testimony here today discussing how to create a more meaningful role for our communities in the decommissioning process. So now I would like to turn to Congressman Keating to recognize him for an opening statement.
Thank you, Senator, and thank all the people that are here. Thank our witnesses. Having a field hearing, is not an easy task. There's a lot to go through. I'd like to staff, Plymouth, and everyone that was involved in that make today a reality. There it goes. Okay. Should I thank everyone again? No, I just am so pleased that we're here on this important issue. That's an issue that clearly was a prevalent issue long before I came to Congress about the safety of the nuclear facility in Pilgrim, and clearly during the period of decommissioning has become a critical issue here in southeastern Massachusetts. This isn't just about the town of Plymouth or the town of Duxbury or neighboring towns of the region. It's about more than that. It's about our important resources and our important industries here. It's about aquaculture. It's about fishing, lobstering. It's about tourism. And it's about the quality of life for people that live in this vicinity. And it's more than that, even. Because as we gather here today, this committee is going to be looking at the larger view of what we can do in terms of the rules surrounding decommissioning. And more importantly, the roles of community and community voices, officials and residents and groups that are affected by things, to have a strong voice in this process, something I'm very concerned isn't the case now. This remains a top priority for me in this region, but beyond that, with so many new plants being decommissioned in the next few years,
particularly the ones by 2025, this is a national issue as well. The decisions and how things transpire here in Pilgrim will undoubtedly affect plants in the entire United States of America. So we're really at a pivotal time, at a very important issue that we have to deal with. This issue shouldn't be decided by corporate profit and loss. It should be decided by public safety and security. And it shouldn't be administered by agencies who say what they can't do, but a government that demands what it must do. And the way this can happen is only through transparency and openness. Sadly, I don't believe that's been the case with Holtec to date. There's still time going forward. And I look at this hearing as one of the most vital starting points for that dialogue to occur. So as we yield for the question and answer period, I'll yield back to the Senator and thank him for doing the hard work it took to put this hearing together here today.
And I thank Congressman Keating for his focus on this issue as well. I chaired a hearing up in Lawrence after the explosion, the natural gas explosion, which clearly identified significant deficiencies in the safety procedures to ensure that that community was not, in fact, endangered, and there was a clear failure there to anticipate those safety problems. This hearing follows on that so that we can ensure that we get all of the questions asked and answered before we run any risk for members of this community. So we now will turn to our esteemed first panel, on which we will hear from John Lobinski, who serves as the Director of the Nuclear Materials Safety and Safeguards Office at the Nuclear Regulatory Commission. Director Lobinski has a wide range of experience at the NRC, having served in a variety of key roles across the agency for nearly 29 years, and has dedicated his career to ensuring public health and safety in his regulatory capacity. Director Lobinski began his career at the NRC as a mechanical engineer in May of 1990, serving in a number of high-profile positions. We will now proceed to Mr. Lobinski and his testimony, and then there will be a question and answer period that Congressman Keating and I will conduct. So we welcome you, Director Lobinski. Welcome to Plymouth. Just celebrated the 400th birthday of Plymouth, the incredible role which Plymouth Harbor has played in the history of our country, which is the reason why we're so concerned. We just want to make sure that everything is done correctly. So we welcome you, sir, and whenever you're comfortable, please begin.
Good morning, Chairman Markey, distinguished members of the subcommittee, and Representative Keating. I also would like to thank the town of Plymouth for hosting this meeting. Appreciate being here today. As you stated, I am John Lobinski. I am the Director of the Office of Nuclear Materials Safety and Safeguards at the U.S. Nuclear Regulatory Commission, and I appreciate the opportunity to testify today to discuss the NRC's roles and responsibilities associated with decommissioning. As an independent safety regulator, the NRC provides oversight during decommissioning to ensure the safe dismantlement and radiological decontamination of nuclear power reactor sites in a manner that protects public health and safety in the environment. The NRC regulations and inspection programs specify actions that both the NRC and licensee must take to demonstrate that a nuclear power plant is decommissioned safely, and that there are opportunities for public engagement during key stages of the decommissioning process.
Could I ask you, Mr. Lobinski, if you could move that microphone in a little bit closer?
Is this better? Thank you. Over the past 25 years, the NRC has gained extensive decommissioning experience and has ensured the safe decommissioning of almost 80 sites, including 11 power reactors. As of today, there are 25 nuclear power reactors at 19 locations across the country undergoing decommissioning. The NRC regulations state that decommissioning must be completed within 60 years of permanent cessation of operations, but do not specify any interim milestones. Of the 25 power reactors currently in decommissioning, 17 are undergoing active dismantlement and decontamination, and 8 nuclear power reactors have been placed in a safe, stable condition to allow the radioactive decay of contaminated material until active dismantlement phase begins. Recently, more retired reactors, including Pilgrim, moved immediately into active decommissioning so that sites could more quickly be cleaned up to levels that permit the release of the property for other uses. For most decommissioned nuclear power reactors, the spent fuel remains in dry storage cask on a concrete pad at the site, which is known as an independent spent fuel storage installation. The NRC will continue to inspect these facilities and enforce regulations to protect the stored spent nuclear fuel until it is removed from the site and the storage facility itself has been decommissioned. The NRC will also continue to independently review the reports that decommissioning licensees submit annually on the status of their decommissioning trust fund to confirm there is adequate funding to complete decommissioning. Finally, the NRC continually evaluates its regulations and revises them to improve the regulatory process. There is a rulemaking underway now to update the NRC's decommissioning regulations, which were last revised in 1997. The NRC values public involvement in its activities as a cornerstone of maintaining strong, transparent regulations, and the agency recognizes the public's interest in the decommissioning process. In response to requests, the NRC has extended the public comment period on the proposed decommissioning rule by an additional 15 weeks for a total of 180 days. During the public comment period, which closes on August 30th, the NRC plans 6 public meetings, including at 4 locations across the country, to provide the opportunity for members of the public to provide input. The last of these meetings will be held in Plymouth on Monday, May 9th, at the Hotel 1620 at Plymouth Harbor. This will be a hybrid meeting so that members of the public can either participate in person or virtually if they cannot attend in person. I want to thank you for the opportunity to speak today on the NRC's role for ensuring that the decommissioning of nuclear power plants is completed safely and is protective of public health and safety in the environment. I am pleased to answer any questions.
Thank you, Mr. Lobinski. So I will recognize myself for a round of questions and just begin by, again, thanking you for your participation. For years, I have called on the Nuclear Regulatory Commission to do more to respond to the concerns of residents around decommissioning nuclear plants, but time and time again, those calls have been ignored. Prior to the NRC's approval, the proposed decommissioning rule last November, I repeatedly wrote to the Nuclear Regulatory Commission asking the Commission to make critical changes to improve public and stakeholder participation, establish a comprehensive set of decommissioning and cleanup regulations, and address concerns about the safety and the duration of on-site storage of spent fuel, an issue of specific concern to the residents who live around the Pilgrim plant. Those suggestions were disregarded, and the frustration you hear from stakeholders and residents is the result of that disregard for the requests which had been made. Instead, the proposed rule allows the Nuclear Regulatory Commission and plant operators to cut corners on safety and limit public engagement at the expense of the communities near nuclear plants, communities like Plymouth. Director Lobinski, Is there anything in this proposed rule that strengthens stakeholder involvement in the decommissioning process?
Thank you for the question, Senator Markey. Let me start with the proposed rule itself. The fact that we have issued a proposed rule for public comment and are seeking public input, including 6 public meetings. Under the Administrative Procedures Act, we are required to post proposed rules for public comment. However, there's not a time frame that says we need to go to 180 days. We felt it was important to extend that comment period so that we can engage with members of the public to provide a full understanding of our background of the proposed rules so that they could provide informed comments. As I noted, we are holding 4 of those public meetings remotely so that we can have in-person communications with individuals. The rule itself will continue to maintain several opportunities from the standpoint of public engagement during decommissioning. The current regulations do require and put requirements on the NRC, not just licensees, but on the NRC to hold public meetings at the time we receive the license termination plan, as well as the post-shutdown activities report. We seek active input from communities when we receive those reports. Also, as we continue to receive license amendments from plants during decommissioning, we have opportunities for members of the public to file for hearing requests. And when there are significant interest in those communities, we do hold public meetings on those amendment requests to seek input. We do evaluate the input provided by members of the community before making final decisions.
Well, I thank the NRC for extending the comment period on the rule to August. We appreciate that. But we are asking about the contents of that rule, what the actual additional protections that will be granted for public participation and the changes that need to be made in order to strengthen the rule. So right now, under this decommissioning proposed rule, assuming no license transfer happens, is there a requirement that the Nuclear Regulatory Commission must consider and respond to public comments on the decommissioning plan?
If there, your question is if there are no transfers
That's
of the
correct.
facility, as I noted earlier, and under decommissioning, licensees are required to provide a post-shutdown decommissioning activity report. Under that report, they're required to provide their plans for how they plan to decommission, and the NRC is required to hold a public meeting. We consider those comments to determine whether or not the licensees are fully in compliance with our regulations and maintaining safety as part of their process. The licensee is required to provide to us for our review and approval a license termination plan. As part of that license termination plan, there are opportunities for hearings from members of the public, and we are required to hold public meetings, and we'll consider that information. So from a public engagement, there are 2 clear requirements in our regulations that require us to have the public engagement and to fully assess the comments provided to us during those meetings.
Well, if the NRC doesn't have to consider and respond to public comments on a plant's decommissioning process, the rulemaking just sets up a show trial. There is already too little input from states and from stakeholders, and the rule would actually codify that. Decommissioning can take 60 years. Perhaps the people of Plymouth and other communities in America never fully understood that decommissioning could take 60 years. And the remnants of the process might last even beyond then. The Yankee Row, a nuclear plant in Row, Massachusetts, was declared by the NRC to be done with its decommissioning in 2007, but its spent nuclear fuel is still on site in Row, Massachusetts, because the U.S. government has for years pursued the false fantasy of Yucca Mountain in Nevada for nuclear waste disposal. And there is a real fear that Pilgrim will be in a similar situation decades from now. State and local shareholders shouldn't have to sit quietly and accept a decommissioning plan that could determine their safety, security, and economic future for decades to come without having a voice today. They will have to live for decades with the consequences of the decisions being made today. They shouldn't be sidelined to just sit back and watch as a company can run rampant over their reputation and interests, and they shouldn't have to fight to get our preeminent national regulator to do its job and actively represent the public interest on what happens to close a nuclear plant. In the latest version of the proposed decommissioning rule, the NRC would have no ability, none, to approve, change, or deny plants' decommissioning proposals known as post-shutdown decommissioning activity reports. So it's like a glorified filing cabinet. The NRC's only job would be to acknowledge receipt and completion, but that would be the role that the NRC would be playing. Director Lobinski, is it true that under this rulemaking that the NRC just checks to make sure that all the necessary parts of the shutdown and decommissioning plan are in the report without having to formally approve the report?
Thank you, Senator. The current version of the rule still requires licensees to provide their post-shutdown decommissioning activities report. It includes for the licensee the requirements on what to provide to the NRC. The NRC does review that report. The NRC reviews the report for multiple purposes. One is to understand from a planning purpose what the licensee will be doing during decommissioning, understanding what oversight activities will be needed during certain phases of decommissioning so we can assure that we are there on site to see the more risk-significant activities that occur, that we can understand and have resources when they submit license amendments to us to make changes to their plant that are needed to go through decommissioning, understanding the timing when they will be submitting their license termination plan, which is the legally binding requirement that is reviewed by the NRC and must continue to be adhered to by the licensee during decommissioning, and the time frame for when it will provide its amendment to do the final termination of the license at the site, which again will be subject to NRC review and approval before the site can determine that it can be released for unrestricted release. During that process, it also allows the NRC to continue to perform its oversight functions at the site through having inspectors at the site oversee the activities of the licensee. So the requirement is still there for licensees to provide the report, and the NRC processes do review the report. If the NRC were to identify in that report any concerns or issues that required NRC action, we could take such action. One of the requirements also is that the licensee must demonstrate that they're bound from an environmental standpoint by previous environmental impact statements that were performed at the site. If they have determined at that point in that report that they have not been bound, they are required to provide to us what those changes are, and the NRC would review those under NEPA to determine whether there's any significant environmental impacts.
Well, but you still don't have to formally approve the plan. You don't have that responsibility.
The requirement for approval falls under the license termination plan, which becomes the legally binding requirement for which they'll do decommissioning.
No, I appreciate that, but at that stage, it's like having a mechanic that checks to make sure you have all 4 tires on a car and tells you you're good to go without checking to make sure that those tires don't have a hole in them. It's a policy designed for a crash. If the NRC had to formally approve the decommissioning activities report, would it be considered a major federal action that would require a new National Environmental Policy Act review?
So if I can go back one step, because you did mention that this is part of the proposed rule. The NRC will be seeking public comment on the post-shutdown activities report. And if interested parties believe it is something we should review, we will consider those comments as part of the proposed comments on the rule. If in the future the NRC would put a requirement in place for licensees to submit for us for review and approval as part of a license amendment for their site, us to approve the post-shutdown activities report, this would be an action under NEPA that we would have to look at the environmental impacts. Under that review, it would depend on the scope of the activities that are included in that report, whether or not we would do an environmental assessment. If we were to reach a conclusion that there was a finding of no significant impact, we would issue an environmental assessment as part of that review of the license amendment. If we could not reach a finding of no significant impact, we would perform a supplemental environmental impact statement.
Has the NRC ever taken action on changing a decommissioning report?
Excuse me, Senator, if I can ask you to clarify, when you say report, are you referring to the post-shutdown activities report or
Has
the
any,
report?
has any plant ever been told that it needs a new NEPA review? Ever?
And, oh, thank you. Thank you for the clarification. You're referring to the NEPA review. My understanding at this point, and we can get back to you with a clarifying answer, is that the reports that have come in, and what I mean by that is the license amendments for license termination, as well as the license termination plan reviews, that all of them have had a NEPA review that has resulted in an environmental assessment with a finding of no significant impact. I am not aware where we have done a supplemental EIS, but I could get back to you to clarify factually whether or not we've ever done that.
Yeah, well, I would appreciate if you would get back to me, but I think you'll find that the answer is in the negative. Does license termination plans have the same information and detail as a shutdown report?
The amount of information in the reports are different because they serve different purposes. Under the post-shutdown activities report, we're asking the licensee about their planning for decommissioning, the type of activities they would be performing, how they would be using their decommissioning trust funds, timing of submissions. The license termination plan provides the details of the criteria that they will use to result in unrestricted release, what activities they will perform to do that. And based on our review and approval, it then becomes a legally binding requirement in addition to their current license that they must meet those items in that license termination plan. Only after we do a review and make a determination that if the licensee were to follow that plan, they would meet all NRC regulations and safety requirements for license termination, would we approve that license amendment.
Has the NRC ever asked a plant to modify a submitted PSDAR?
Under the regulations, that's a report that's required to be provided to the NRC. We have asked questions.
No, I'm asking, have you ever asked a plant to submit a modification of their submission?
I believe we have asked questions of the licensee that has resulted in them submitting changes. We have not required them, to my knowledge, but I can get back to you to submit a brand-new report.
And again, you can understand why that doesn't seem, as a result, as a very effective check on how the owner of the plant would be viewing the NRC's rule if no modification has ever been requested. If the NRC had to formally approve the decommissioning activities report, would that provide an opportunity for stakeholders to challenge the activities outlined in the report through an adjudicatory hearing?
If the NRC were to put a requirement in place that required to review and approve on a license amendment to be submitted for the incorporation of that report, there would be opportunities for hearing.
Yeah, and I agree. It makes more sense to me to conduct an environmental review and give the public, those sitting here today, an opportunity to weigh in before the decommissioning process begins. This would have helped avoid a lot of the problems our communities have experienced with pilgrims decommissioning process so far, with the community's alarm over the Holtec plan to dump 1 million gallons of radioactive water into Cape Cod Bay being just the latest example. Don't you think that makes more sense, Mr. Lobinski, that the process have the public participation, the public questioning up front rather than after the fact?
I believe right now the requirements that we've put in the proposed rule, as well as the current regulations with respect to the post-shutdown decommissioning activity report, are adequate to protect public health and safety. This is the reason that when my staff submitted the report to the Commission for approval, we did not put a requirement for that to be a license amendment. With that said, we are actively seeking public input to determine what the final decision would be. I believe from a safety standpoint, our oversight and the remainder of our licensing activities do provide adequate protection.
Well, again, the community does not agree with you, and more public participation is needed. So, as you're aware, last December, Holtec announced it intended to dump 1 million gallons of radioactive water from the spent fuel pool, reactor pool, and other areas of the plant into Cape Cod Bay, claiming it had the green light from the NRC to discharge the water at any time. And while the NRC has acknowledged that Holtec's National Pollutant Discharge Elimination System permit will almost certainly need to be amended by the Environmental Protection Agency before the discharge is allowed to account for non-radiological water pollutants, I am concerned that the NRC has failed to engage with all federal agencies that have a stake in the matter. My office has spoken with NOAA's Office of National Marine Sanctuaries, which has informed us that under the Oceans Act, federal agencies are required to consult with the Office of National Marine Sanctuaries on federal agency actions that may affect any sanctuary resource, such as the Stellwagen Bank National Marine Sanctuary. Given that the Stellwagen Bank National Marine Sanctuary encompasses the waters at the mouth of Massachusetts Bay between Cape Ann and Cape Cod Bay, I would contend that the dumping of 1 million gallons of radioactive water into Cape Cod Bay may affect the Stellwagen Bank National Marine Sanctuary. Director Lobinski, has the NRC consulted with the Office of National Marine Sanctuaries about Holtec's proposal to release radioactive water into Cape Cod Bay?
Thank you, Senator. With respect to our coordination with other agencies, we do that under our NEPA process when we look at our environmental impact statements. With respect to Pilgrim, environmental impact statements were performed during operation of the plant, license renewal for the plant, and that the NRC did also have a generic environmental impact statement for decommissioning. We've determined that all of the activities at the plant are within the scope of those documents that were reviewed. As part of those reviews, we do look at marine sanctuaries. We are required to consult with the national marine sanctuaries if we identify any impacts that we believe would destroy, cause the loss of, or injure a sanctuary. It was determined as part of those reviews that that impact would not occur to the sanctuary, and therefore formal consultation did not occur. We are in receipt of a letter from National Marine Sanctuaries asking about our decision on that, and we're still evaluating that letter, and we'll be providing a response.
So the Office of National Marine Sanctuary sent the Commission on March 14th a letter regarding the issue. You haven't responded to it yet. I would ask you to respond in a very timely fashion, especially since you are going to be having a public hearing up here. You know, everyone here should know what your response to them is. And so you've had it on your desk. It's sitting there. It needs a response. The people here deserve that. because one of the issues that people are so concerned about is the economic damage to our vibrant blue economy here in Massachusetts and on the Cape. The shellfish, the seafood, the tourism industries all depend on clean, healthy water and their reputation for safety to make a living. Director Lobinski, does the NRC have a responsibility to consider these issues when establishing its standards for the release of radioactive water?
Thank you, Senator. In response to your first statement, we will be responding to that letter of March 14th. I can commit to you that we will be doing that. With respect to the release
You
of...
cannot commit to when you will be responding to it. Is that what you're saying?
I do not have a date right now, sir.
I
Thank
think the people who are going to be attending the public hearing have a right to know what the answer to those questions are before you have the public hearing. You've had a sufficient notice in order to do the work. I would ask that you ensure that your staff, the NRC, does the work to guarantee that that material is in the hands of the people from the community of Plymouth.
If I could ask for a clarification, Senator, when you're referring to the public hearing, which public hearing are you referring to?
That you're going to be having on this issue. Monday, May 9th.
The Monday, that is not the subject of the meeting we're having on Monday. It is not a hearing. This is a meeting on the decommissioning rule itself. It's not specific to any specific plant. I will strive to be able to provide Monday a commitment of a date when we will be providing to the letter, and we would not be providing something in a public meeting about a response to an individual without responding to them first. So we do want to make sure that we put something in writing, and we will strive to have a date by Monday of when that response will be issued.
Well, again, that's the concern which the community has. These are the issues that they are concerned about: the impact on the community, on safety, on the water, on the economy, on the fishing industry. And I think that obviously the questions that have been raised by the Office of National Marine Sanctuaries is directly relevant to why these hearings are being held. They want the answers to the questions. NEPA reviews require the consideration of ecological, aesthetic, historic, cultural, economic, social, and health effects of federal action, but no NEPA review was required for the decommissioning plan because its approval isn't considered a major federal action, and the new decommissioning rule would not change that. Director Lobinski, would a new NEPA review for decommissioning mean that the NRC would have to evaluate the effects of decommissioning activities, such as radioactive water dumping or the cultural and economic well-being of the region?
Thank you. With respect to the release of water into the Cape Cod Bay, that was something that was looked at during the operation of the plant as well as during license renewal. Under the NEPA process is something that we would look at under the environmental impact statement. As I mentioned earlier, we did look at the marine sanctuaries as part of those reviews. The requirements that are on Holtec today and previously on Entergy for the release of that material still apply today. What applied to Entergy applies to Holtec today, and they will be required to meet those standards. We have done a review of that under NEPA, as noted in the EIS and the supplemental EIS that was done for license renewal. So that was accomplished. If, and I use the word if a new requirement was put in place under decommissioning that would require an amendment to the license, we would do a review and meet our NEPA requirements. And depending on the scope of that, whether or not it would be an environmental assessment or an environmental impact statement would have to be determined.
Yeah. So the the concerns obviously are great about the impact which that radioactive water could have on the community. The International Atomic Energy Agency is the preeminent global body for promoting the use of nuclear power. On the subject of releasing radioactive water, the International Atomic Energy Agency writes, I quote, "There are also public relations and environmental issues to consider. For example, there are instances where effluent is within the discharge criteria and may be authorized for release, but discharge may be unacceptable in terms of public relations. The political and environmental aspects need to be considered during the stages of planning and licensing of decommissioning. Will the Nuclear Regulatory Commission follow the advice of the IAEA and consider the environmental and political implications of allowing Holtec to dump 1 million gallons of radioactive water into Cape Cod Bay?
Thank you, Senator. As an independent safety regulator, we have looked at what the impacts would be of radiological safety from release by Holtec of water effluents from the site. We believe that the requirements in place on Holtec today would ensure public health and safety from the release of that material from a radiological standpoint. With respect to reviews that are done, such as on socioeconomical impacts, we do look at those when we perform an environmental impact statement. That would have been looked at during operation as well as license renewal, because again, it's the same requirement today that they had during operation for the release of that material. From a public relations standpoint, we do not look at the public relation aspects of such releases.
Well, the NRC has essentially cut itself off from any ability to mitigate direct or understand the site-specific issues around water discharge, and that is a problem. As the decommissioning rule currently stands, NRC gets to wash its hands of any radioactive water and leave our residents to wade through that issue on their own. But that doesn't have to be the case. Under current federal regulations, the NRC could actually set more stringent radiological standards for Pilgrim's water. Director Lobinski, is the NRC looking at using this authority as a result of the specific economic and ecological concerns raised by local stakeholders?
Currently today, the NRC, through its licensing process and regulations, has requirements on Holtec at the Pilgrim site that govern the release of the material. They are required to meet those requirements. They have a radiological environmental monitoring program that would determine, based on a release, what the dose would be to members of the public for that release. They must meet the NRC regulations for that dose criteria. We have NRC inspectors that review these programs on an annual basis to ensure that licensees are meeting those requirements. We believe the current requirements are sufficient to protect public health and safety. As part of the proposed rule on decommissioning, we have not proposed changes to any of those effluent releases. And at this time, with respect to Holtec's operation in Pilgrim, we have not identified any issues that will lead us to believe we need to put more stringent standards in place.
Well, the reason it's an important issue is that the proposal will allow for 3 times as much water released in 1 year as Pilgrim has ever released in the past. And the old conditions, as a result, are not the same. And when you talk about public relations, what you're talking about is the economy of Plymouth. You're talking about the culture of Plymouth, how people view Plymouth, how people view the water of Plymouth, how people interact with this community, whether or not that becomes associated with how this community is viewed. And so it's a critical issue because this is an historic community with an underlying economy and culture which has to be protected. And I'll just conclude this phase of my questioning and just make a motion to submit testimony. I have testimony from the Massachusetts Lobstermen's Association, local residents and realtors, and local elected officials detailing those concerns. And I ask unanimous consent that this written testimony be submitted for the record without objection, so ordered, so that the public comments will be included in the Senate hearing record. and submitted to the NRC as part of their consideration. So I'm going to stop my questioning at this point in time and recognize Congressman Keating, who has been a real leader on this issue of the discharge of radioactive water into Plymouth Harbor.
Well, thank you, Senator, and thank you, Director Lobinski. I'm not sure of the Senate rules in this regard, but oftentimes in our House hearings, if time does not permit and there's the ability to ask questions in writing after, we do that. If that's the case, Director, could you give your assent to answering those questions? I've had community people ask me, certain issues that the times don't, allow all of them to be asked. But if that can be done as part of this hearing and get an answer, would I have your agreement on that?
Thank you for the request. I will defer to Chairman Markey as far as for protocol. We will, my understanding is, receive questions for the record after the hearing, and we will, of course, respond to those. As you said, Senate protocol. I will defer to him with respect to Representative Keating. If you have specific questions that you would like to submit to the NRC, either related to this hearing or separately, we, of course, respond to you with those questions.
And again, the Senate committee will be accepting questions from Chairman Copper, Ranking Member Capito, and Inhofe, and other members who have a concern on this, including answers to any of the questions which Congressman Keating will be posing to the NRC for written response.
Thank you, Mr. Chairman. Now, I've been listening, as I think everyone has been here, to the colloquy back and forth with you and the Senator, and it just strikes me as it's a process where, you're all dressed up with nowhere to go. That's what it sounds like to me. It sounds like as long as the person, if the word is, well, it's formal, okay, make sure you have the tux and the bow tie on, and then you give the okay. I mean, that's what I heard, but I want to dig down a little bit and just be clear, because I think people here, after listening to all that, want to really just get this question answered too. Will the new decommissioning rule address the ability of the licensee to discharge 1 million gallons of radioactive effluent into the spent fuel pool, from the spent pool into Cape Cod Bay? Will the new proposed rule address that ability in any way that doesn't exist now?
Currently, there are requirements in place for the discharge.
New proposed rule, will that be doing anything else in that specific regard than exists now?
If I can, it is making no changes to the current requirements. There are current requirements that govern that.
That's all I wanted to know. I wanted to know about the new rule going forward in that regard. And again, to this process, it's so unilateral. It's just by definition. Just the example that was given in terms of marine sanctuaries. So the NRC will look at it, and if they identify something that they think is an issue, then they'll reach out and contact an agency that's on the ground or in the water in this instance, that knows more specifically about the impact, not only from their own experience, but from their ability dealing with community groups. So, just have the NRC, have the rule be, and have the practice, because I don't think, you're not prohibited from going further. I understand that. So I don't understand the adherence to rules when you're allowed to go further, when you have expertise there, not only in terms of the science, but all that community work that those groups do dealing with their issues that would be relevant to what you're looking at. So this concept, I was hoping in the new rules that there would be some kind of change in that regard, but it isn't there. And specifically, in terms of your testimony here today, I was struck with this concern, that it sounds to me that you're looking at this change to dump 1 million gallons of effluent in Cape Cod Bay, radioactive materials, the same way that you've looked at in the past the discharge in other years with a commissioned nuclear facility doing 1/3 less of that dumping. So is that accurate? Did I get that right, that the way you're viewing this going forward is the way you, with the same criterion that you looked at in the past? It sounded that way to me.
So if I can clarify one of the statements that you made, and I believe Senator Markey made as well, with respect to the volume of water, the NRC does not regulate based on the volume of water. We regulate based on the dose that to the members of the public as a result of the release. So many things are taken into consideration. It's the volume of the water, the level of contamination, water from radioactive material, the different
Okay,
levels.
my
So
time is limited, so I just, excuse any interruption, but this is what we do because, this is what we do in Congress when we have to get some quick answers
if I can
across
give
the
you the
board. So I apologize for that, but you take into review, Cape Cod Bay is a little different than other places. I mean, the construction of it, do you ever see, you know the map with the arm and the bay and how that's all included in there? This is just me as a layman. There's a Woods Hole scientist that was particularly concerned with the fact that the construction of, the topography there, that it's not a free flow into the ocean, that it's bounded in part by that. So when you're looking at these rules, how did you particularly look at the construction of Cape Cod Bay itself, and the fact you're just not dumping it straight in the ocean?
We look at from the dose standpoint what the dose would be, and it does take into account how the distribution of the water would go into the bay. It looks at the volume, it looks at the concentration.
Oh, could I see those studies, if you will, that you particularly looked at Cape Cod and did that? Do you have that available?
I do not have information available about
Was it done?
specific studies with Cape Cod.
Was it done
I-
specifically in
the
that
li-
regard? Or
the-
just how many doses people get a year?
The licensees are required to demonstrate under their radiological environmental
you have-
monitoring
excuse me.
program.
Here's the point I'm bringing. The licensees are required to do that. I think you should be required to do it, and that's where the weakness in this process occurs, frankly. So that's something you should be looking at, not just, well, the licensees are required, and if they miss something and you miss something because of the unilateral way it's being done, then it's missed.
We review those programs before they implement them, and we also look at them through oversight programs.
Good. I want to shift gears if I can, Mr. Chairman, just for a minute, because I want to just take your experience in this regard and see what we can learn from it, or what I can learn from it. You're involved, or your agency was involved in the process that surrounded Vermont Yankee Power. Is that correct?
Excuse me, can you say that again?
The
I didn't get
decommissioning around Vermont Yankee Power?
Yes.
And so in that instance, could you describe the process? That was trucked away. That's a situation where where radioactive material is trucked away, and that received approval. And, can you tell us how that is feasible and how that's worked and why that is an option, an alternative that you gave, you went along with a licensee in dealing with that? Could you describe, the feasibility and how that can work here?
Again, there are multiple options for disposition of material during
But that's the
decommissioning.
one I'm asking about.
And they could, at this point, right now, a licensee could take volumes of material, I'll say ship them away. It could be in trucks. It could be in tank cars on railroads, taken to the sites. Licensees could use evaporation at the site to evaporate
Right,
the
I'm aware
water
of
and
that.
dispose of the material. It's long as the regulations are met from the standpoint of the public dose limits and they meet our disposal requirements, they can do that. So with
So you would
respect-
term that a very viable alternative,
It is one viable alternative.
but it is a viable alternative.
It is a viable alternative.
And with Vermont Yankee, how's that going there?
I do not have information on why they made that decision. Part of that was a business decision they made on doing it that way versus other options. That was up to them. It's our job to make sure
Excuse me,
whatever they're
Steve,
doing is safe.
I'm interrupting just to make a point. That was up to them. That's the whole point of this hearing, I think.
As long as they meet our regulatory standards, which they did, and we will only allow Holtec to release material as long as they're meeting our standards.
Yeah, well, I want to tell you this. The reason you're seeing so many community people here today, the reason we're here, we don't disagree with, it's up to them. That's what this is all about today. This is what it's been about before. And I'm telling you this, it's going to be what it's about going forward. So with that, Mr. Chairman, I'm going to yield back so that I know our time has gone by, but thank you.
No, it's fine. And if you have additional questions, you can be recognized for that purpose. And again, I just want to continue with you, Mr. Lobinski, so that we can put some of these other critical issues that people really do care about here in Plymouth, but also across the country. Because without a viable solution for the long-term storage of nuclear waste, it's clear that spent fuel will remain in dry casks at independent spent fuel storage installations for longer than originally anticipated. Those casks, exposed to the elements for decades, could decay and potentially release additional radioactivity, jeopardizing workers and the environment. So, Director Lobinski, does the NRC require spent fuel storage site licensees to have formal plans in place for how it will deal with any dry casks that are damaged or leaking?
Thank you, Senator. With respect to the dry cask storage, as you mentioned, in an independent spent fuel storage installation that is governed by our regulations, the certificate holder, as we refer to them, who designs the cask, has their plans in place that they provide to us for review and approval. Once we approve those, the licensee at the site must meet those requirements. As part of aging management, we do require licensees to identify what we call aging management programs that will inspect, meaning the licensee will inspect the canisters for any potential damage. If it is identified, it is up to the licensee to repair or mitigate such damage moving forward so that they can continue to ensure that it meets our regulatory standards.
So how often are individual dry casks with radioactive material at the Pilgrim plant fuel storage installation site being monitored and inspected? How frequently does that happen?
So inspections by the licensees, there are different types of inspections they do. For example, they do need to monitor to make sure that the vents around the canisters are kept open so that they get adequate ventilation. That is done periodically based on the conditions because, again, it's a static site. So it would depend if there was snow in the area, leaves blowing around, any debris. They would be the times that would implement that. Plus, they have periodic times to do that. The aging management requirements would be part of the certificate of compliance. Our understanding is that the certificate of compliance that they're using at Holtec is using at Pilgrim. We are reviewing their aging management program at this time. They have proposed that they would review one cask every 5 years to do a detailed inspection to determine if there's damage. If there were damage identified or any repairs needed, they would have to expand that review. But if there was no damage, it would be once every 5 years. We have not approved that yet. We are still in the process of reviewing that aging management program. Because it is a certificate of compliance, it requires rulemaking. And the proposed rule will be issued in August of this year with our final decision on that aging management program.
Well, I don't think that that is going to be acceptable to the people here in Plymouth. Holtec is proposing to inspect one spent fuel canister every 5 years. That's it. Once every 5 years to look at one canister to see if it's leaking. I don't think that the people in Plymouth are going to feel very confident that there isn't a leaking canister, that there isn't danger lurking in the community because that the company Holtec is seeking to have the NRC give them permission not to inspect much more thoroughly, much more frequently, to ensure that this very dangerous material is not, in fact, leaking and exposing the community to that risk. So I know I wouldn't trust checking one of them every 5 years. And I know that the people here don't trust them either. So Holtec, I'm sure, is going to say, well, we're the experts, and you don't have to worry. But the people of Plymouth don't trust the experts anymore. They want to ensure that there is, in fact, an ongoing, careful, meticulous monitoring of these dry casts so that this dangerous radioactive material does not leak into the community. And finally, on the emergency planning zone issues, I'm deeply troubled that the proposed decommissioning rule would essentially codify the process of regulating by exemption, where the NRC just takes regulations off the plants as they become less applicable, rather than creating a new framework to specifically reflect the changing needs of a decommissioned nuclear rule. That means other communities could go through situations like the one we saw for Pilgrim, which was granted exemptions from key NRC regulations on seismic testing, cybersecurity, off-site emergency planning. We're in a period of great tension with the Russians right now. We're constantly being warned about cyber attacks that could occur in our country. We know that nuclear facilities would be near the top of the list of those kinds of facilities that could potentially be attacked. So the off-site emergency planning exemption means that a plant can cut its emergency preparedness procedures, including for public notification of problems on the site while spent nuclear fuel is still sitting in pools and before it's even put into dry cask storage. So before we even get the minimum level of safe storage, plant operators can already walk away from their responsibilities for the community's safety. FEMA's own recommendations urge communities to maintain radiological emergency planning capabilities until all fuel is in dry cask. So, Director Lobinski, if our first responders want to follow FEMA guidance and stay prepared for radiological emergencies, would the proposed decommissioning rule put the financial and training burdens for decommissioning solely on the communities and not on the company?
The new proposed rule, if I can go back, the new proposed rule does include changes to emergency planning zones, as you said, when fuel was still in the spent fuel pool, but only after which time that we have determined that the likelihood of any type of accident that would result in an off-site dose above the Environmental Protection Agency's protective action guidelines would not be exceeded. So it's a graded risk-based approach based on that type of event being highly unlikely. So therefore, that was the basis for putting it into the proposed rule. And as we noted earlier, the proposed rule is up for comment, and we're actively seeking comments on that requirement. So from the standpoint of if it is approved, and if licensees go forward, it would not be a requirement of the licensee, and communities could, if they chose to, continue to implement such activities, but it would not be a requirement of the licensee.
Yeah, so obviously the communities are concerned by that because an exemption the NRC has allowed to Holtec in the transfer of the license allows Holtec to stop paying for emergency planning to area towns. For example, the town of Marshfield is going to lose $450,000 a year. And we actually have the Director of Emergency Planning, Artie Shaw, and Town Manager Michael Moresco here, and we're going to accept their testimony later. But from my perspective, again, the proposed rule is penny-wise for nuclear plants and their operators, but pound foolish for communities who have already been largely ignored. And I urge the Commission to reconsider and strengthen it instead, just to make sure that in the event of a emergency, and may determine that it's a low level of risk for the people who live here, their perception is going to be that any risk is one that they don't want to run, and they're going to need, as a result, a way of evacuating if necessary. So I just give that to you as well, Mr. Lobinski, for your return back to Washington and the NRC. The emergency planning is absolutely essential. So let me turn again to Congressman Keating and ask if he has any additional questions.
Thank you, Mr. Chairman. When it comes to the limits of the NRC, one of the things that is always a concern is the fact that so often you're getting notified afterwards. So the damage is already done. And then things may get brought to the NRC's attention that way. I mean, that whole concept of how this is done, as long as, for instance, the discharge in this instance is below the EPA and NRC limits, Holtec doesn't have to even alert you of that. Is that correct?
It is, when you say it's done and we notify afterwards.
If they're saying it's below the limits, they don't have to alert you even.
They do have to, before the fact, not after the fact, they do have to get prior approval of the exact methodology that they're going to use to ensure
But there's
they're meeting the
there's
limits.
no oversight about what's getting discharged. Just, they're saying this is the method, this is the approval, but then they discharge, and then if it goes over afterwards, then they come back to you.
Our approval of that process provides reasonable assurance that it will be below the limits. If it is above the limits, yes, it would be after the fact. But our
yeah.
process of a prior approval, we
yeah,
believe
no,
provides reasonable assurance that
aware
it
of
will
that.
meet
Now,
that standard.
They don't have to give you information about boron or heavy metals or everything in this mixture, because, you know, there's the potential of mixture. We're just talking about one impact on the radioactive side. But there are other things of concern, and frankly, they're of great concern, and I'm glad they are, with the Department of Environmental Protection, federally as well as at the state level as well, the EPA at the federal level, Department of Environmental Protection at the other, because of these potential mixtures that are being introduced into the water. So there's Clean Water Act concerns with that as well. But it's this type of reliance on the corporation itself, without that kind of oversight, unless I just gave you examples, the damage is done, and then you're looking back at it. It's what you said before about the fact, well, when it comes to the company, it's all up to them. Well, if it's all up to them, it would be profit and losses, not public safety and security. And that's the problem. I was hoping in these new rules there'd be greater avenue with the NRC to do that. It doesn't appear that's being done, and we'll have the opportunity, I think, in the next panel to deal with things that perhaps can be done at the EPA or at the state level with DEP. So I'm finished with my questioning, Mr. Chairman, and I yield back.
I thank you, Congressman. And so I'll just finish up with you, Mr. Lobinski, and thank you for coming up for this hearing. And so the concerns which we have, obviously, I can summarize for you. I think we need that the NRC accept the fact that post-shutdown decommissioning activity reports should be approved the NRC in order to ensure that there is support for community and stakeholder involvement, accuracy, and environmental review, but there should actually be a vote by the NRC accepting the report and not just accepting it and putting it into a filing cabinet. Secondly, that the NRC commit to coordinating with other agencies and assessing the water dumping issue. NOAA's National Marine Sanctuaries Office, EPA, Mass Department of Environmental Policy. We need to have better coordination. And finally, maintaining requirements for emergency response and preparedness, at least until all fuel is out of this spent fuel pool and put into dry casks. And that is not the case right now. So I just wanted to summarize that for you, tell you what the concerns are going to be as we're moving forward to make sure that we get all of the answers and the protections which the community is expecting. So we thank you again, Mr. Lobinski, for being here. We will be submitting questions in writing to you. We would ask for a timely response to those questions, and we thank you very much.
Thank you, Mr. Chairman, and thank you, Representative Keating.
Thank you, sir. And now we'll move to the second panel, and we will be hearing from Dr. Chris Singh, the founder, president, and CEO of Holtec International, which he established in 1986 and has nurtured its steady rise into a multinational company with its business footprint in 18 countries on 5 continents. After that, we're going to hear from Jeff Fettis, the senior attorney for the Natural Resource Defense Council's Nuclear, Climate, and Energy Program. Mr. Fettis both litigates and testifies before Congress for the NRDC, where he focuses primarily on issues relating to the beginning and end of the nuclear fuel cycle, including issues associated with uranium mining and the disposal of radioactive waste. Following Mr. Fettis, we'll hear from Massachusetts State Senator Sue Moran, who represents Plymouth and Barnstable District. Senator Moran serves as the Senate Chair of the Joint Committee on Consumer Protection and Professional Licensure. And we know that each of them has a valuable testimony to provide to us because they have lived and worked on these issues. So we welcome you up. If you could come up and please sit behind your name cards, then we can begin the second panel. So we're all now in the advanced use of Zoom, and we understand how it can transform our lives, including public hearings on issues of great concern. And Dr. Singh is joining us in that fashion. We thank you so much for testifying here today. So whenever you're comfortable, Dr. Singh, please proceed with your statement.
Thank you, Mr. Chairman. Thank you, Senator Markey, and the members of the government legislative branch to participate and to hold this meeting, this hearing. I personally appreciate the opportunity to provide accurate information to help people make their decisions. And I think a meeting like this, a hearing like this is extremely valuable in that respect. Let me first categorically state that decommissioning is not our preferred business. We decommission because plants, after they have operated for a length of time, they need to be decommissioned. They need to be decommissioned, and there has to be a renewal. We will build a new plant if the community so wants, or we will converted into condominiums or what have you. It will be we always look to do it in the minimum time. 60 years is permitted under federal regulations, but we try to do it as fast as possible. Actually, at the current time, Pilgrim is way ahead of this decommissioning schedule that we had initially proposed. Thanks to the high quality of workers we have, most of them drawn from local community, our management team, we are doing much better than what we had projected. I'm also delighted to tell you that there has been no personal safety incidents. We have been an excellent steward of the environment, and we'll talk about the water discharge very shortly. And we have minimized dose to people. Our performance at Pilgrim would rank as A+, if you look at all the metrics of performance. And I don't intend to be defensive here. I just want to give you the facts. You can always compare them with the data across the world, across the industry. Let me first address the issue of consultation before the ownership transferred. In the case of Pilgrim, there were extensive discussions with the state of Massachusetts. I even spoke to the governor. I met with the attorney general. There were many, many discussions between the two parties. It did not happen. The transfer of ownership did not happen in the dead of the night. As a matter of fact, we have serious financial obligations if we don't perform as contracted, the decommissioning work as contracted with us from Entergy. Pilgrim fuel has been taken out of the pool. Every fuel assembly is now out of the pool, Senator, and it's in dry storage. So the emergency plan that you said it should not be terminated, should not be diminished until the fuel is out of the pool, that has already occurred. And by the way, it has occurred, it beat the world record this time. We transferred fuel faster than it had ever been done before, out of the pool to the pad. Why do we consider it important? Public health and safety. A fuel pool obviously is not as structurally robust. It is a robust structure, but not nearly as robust as a cask. A cask, you can take a missile, hit it with, and you will not have a leak. Actually, Sandia has analyzed that. Our cask, it would survive and prevent any release of contamination if it were hit by a crashing aircraft. So we wanted to make sure that the fuel got out of the pool as rapidly as possible, as safely as possible. And I'm pleased to tell you that we have successfully done that for the people of Plymouth and vicinity. I should also tell you that San Onofre, 8 years ago, when they decided to add on-site storage capacity at San Onofre, Southern Cal Edison, selected our below-the-ground storage technology because of the ungodly high earthquakes that they can experience, as you correctly mentioned. There are fault lines there that can create significant earthquakes. And we have designed it for an earthquake level, and the facility is operational. I'd love to show it to you. The facility is operational, and it's been qualified and agreed to both by California Coastal Commission and the NRC that it will withstand earthquakes, which have never been experienced in recorded history of this planet. That is how rugged and robust the cask system at San Onofre is that we installed in 2014 to 2018 timeframe. Okay, Indian Point, likewise, I should just correct the record. Indian Point went through extensive negotiations and discussions with the state of New York representing the public and also local NGOs like Riverkeepers. They engaged with us. They wanted to know how we will do the work and what kind of responsibility we would undertake. We satisfied them all, only then did we do the deal with Entergy. So there may be a higher level of control. I don't know. I'm sure we can conceive of other additional constraints in these transactions. But if you can look at the records, just these plants, we did Oyster Creek. Oyster Creek is further along than Pilgrim. We have done Pilgrim substantially, gotten all radioactive fissile material out of the plant into its fissile pad, as you said earlier. We have done these things, and Indian Point, by the way, is substantially on way to decommissioning also, way, way ahead of schedule. So I think we have lived up to our commitments to the state governments, to other stakeholders, and frankly, to ourselves. We have an obligation to perform decommissioning to the highest levels of standard of safety, environmental protection, preventing spread of contamination. We have never had any spread of contamination at any of our sites. And of course, the last most important item, to provide a pathway to get fuel out of the plant, out of the state, to a more hospitable place. Now we are unique in that respect. We have been working with the people in the state of New Mexico, southeast New Mexico, where fuel can be taken from Plymouth. Fuel can be taken from all the plants in the country and aggregated at one consolidated interim storage facility, which was the stated wish of the Department of Energy from some 10 years ago. We have done that. We expect to get the license from the NRC. It's not a regulatory problem. It's not a technical problem. It's a problem of political will. The Congress has to ask DOE and provide them with the funding so the fuel can be transported off-site. The technology is available. The technology that we are licensing with the NRC in New Mexico is so radiation efficient that you can hold a barbecue on top of that facility and not get radiation exceeding the federal limits. So we've done technically what needs to be done. Now it's the time of our leadership, political leaderships, people, folks as you, to take this step to get the government to give us the way so we can get the fuel out to New Mexico. The idea of consent, it's a vague language in the law, public consent. The people of southeastern New Mexico, the host community, are 80% in favor of this facility there. All ducks are in a row. But if we don't do, you have the power, Senator, to ensure that this happens. We don't. We in the private industry, when we open our mouth, people think we're looking for profit. So how do we deal with the problem? Take a look at our record, please, and you would see that we have always had public interest first and foremost in our minds. We are spending money on decommissioning Pilgrim on a fast schedule so the facility becomes available for redeployment and the township can get new tax revenue base. That's why we are doing it. That's the main benefit to the community. We get rid of all contamination from the site. And we are successfully doing it. But then this facility will remain there unless we are given the permission and the means from the government to move it out of state. So I call upon you and all other senators to get together on this issue and show the national will to get the fuel out of places where it doesn't belong. The spent fuel should not be sitting in Plymouth for the next 60 or what years. Take it to a consolidated interim storage facility. There, the air is dry. There is no marine air. The temperature is right for the fuel. It will live there. It can live there. It won't live there, but it can live there for 1 million years without springing a leak. But we do the work, but we cannot, we can make all technically everything possible, but we don't control the levers of policy. So that is, if you hear frustration in my voice, yes, the fuel doesn't have to be stranded. Fuel can be sent to a proper place where it will be safely stored below the ground for as long as necessary until a repository becomes available, or the fuel is repurposed to produce more energy. I personally believe that the fuel has an enormous amount of energy that can be used later and produce clean electricity. But then, if that is not the government policy down the road, put it in the repository. But it is there. It is there in a safe. If you put fuel in New Mexico today, in southeast New Mexico, in 20 years, you see no evidence of corrosion because there is no actuating condition at the site to create corrosion. It's a perfect site, but that's about how far we can go. We are not going to sit for 60 years on decommissioning. We're going to have Pilgrim decommissioned in 12 to 15 years. It will be done. But the fuel, moving the fuel, sir, it's up to you and your colleagues. I will address the issue of water discharge. I just want to get everybody to realize that it's not an operating plant. When Pilgrim was operating, there was a whole lot more discharge into the bay on a continuous basis. You asked a question about has anybody done the analysis. It so happens that Pilgrim plant had hired Holtec about 20 years ago to do that particular evaluation. I'm sure we have a report in our files that studied the situation in the bay. The concept I'll leave with you before I'll take questions and answers. In engineering, in science, the operative concept is factor of safety. You design it to a factor of safety always more than one. And the extent of safety in a particular operation is, the metric is the factor of safety. An airplane that we fly is designed with a factor of safety of 2 under the worst storm, postulated storm it may have to fly into. It has a factor of safety of 2, an aircraft. The water discharge has a limit from EPA and the NRC, and then there is the actual values. The observation at Pilgrim have shown that we have a factor of safety of 200, not 2, a radiation at discharge from the processed water in the plant. By definition, it is not contaminated water. It's processed water and it does not meet the threshold of contamination. And NRC standards, the factor of safety is 800. Now, there is nothing, sir, that we live around, our houses, our office buildings and all have anywhere that kind of factors of safety designed to it. So I would not say, I wouldn't call the water contaminated, and I would say just lumping it because it's coming out of a nuclear plant as a potential hazard to people is not based on science. And of all places, New England is the birthplace of science and technology in this country. You have the best institutions. So I would think that you will subscribe to the notion of factor of safety far more than other people would in other countries where science is not necessarily all that developed. I will stop right there and I'll be glad to take questions. Thank you.
Thank you, Dr. Singh. Now let's turn to the other witnesses, then we'll come back to you, Dr. Singh. We'll begin again with Jeff Fettis, who is Senior Attorney for the Natural Resources Defense Council's Nuclear, Climate, and Energy Program. Welcome, sir.
Thanks to all who've invited me here. How's the sound? Good? Thank you, Senator Markey, Chair, the ranking members, Representative Keating, the other distinguished members of the room. We've already had a long morning, so I'll be concise and quick so we can get to the questions. Unfortunately, decommissioning should be a straightforward, methodical, and not particularly controversial process. That's not where we are. The largest issues facing communities right now, and especially Plymouth right here, as we've heard this morning, is the lack of a clear set of strong and protective guidelines that are implemented by a strong and clear regulator. Any final rule that's going to be done by the NRC, and thank you for extending the deadline, but that's the least you can do right now, is going to be in place for decades and affect the cleanup, communities, and the associated workforces of more than 60 sites across the country. Whether the shutdown of reactors happens in the next 5 years, 10 years, 20 years, it's going to happen. And this rule is probably the last good effort to get it right. Many of the challenges that we've talked about this morning and that I've listened to here in Massachusetts could have been avoided with an improved set of regulatory requirements. Let's not revisit those harms and struggles on other communities as this process unfolds across the country. The proposed rule in its current form is inadequate. It should be withdrawn and reissued in much stronger form along the lines of what Senator Markey has outlined here today. But let me be precise about 3 key issues, or actually 4 now I've added since the morning's gone on for a bit. Number 1, the NRC needs to require a decommissioning plan prior to the shutdown that allows for a full environmental review of the necessary cleanup and with the associated hearing rights that allows the agency to fully inhabit its role as a regulator. Honestly, just stepping away from my prepared remarks, it's an extraordinary abdication of regulatory oversight for the NRC. Let me be clear. They actually, it's just as you said, Senator, it's a postal clerk's job to accept what's called the PSDAR, the decommissioning plan. There is nothing that they can require from it, less, more, different. Every site, whether it's Zion in Illinois or Plymouth in Massachusetts or Diablo in a few years in California, is going to have different needs, industries. I'm glad the lobstermen are here today. I'm glad the state senator's here today. Every place is going to have its own idiosyncrasies and needs that have to be taken into account. And right now, the decommissioning plan that goes forward, the NRC literally has no regulatory role other than to mark that it approved it, or other than to mark that it received it. It's an extraordinary abdication and really unprecedented in NRDC's view of the federal government, because we work across all kinds of issues, as both of you know. Next, it's crucial to require the industrial cleanup, the decommissioning process take place as soon as practicable after a reactor shuts down, and with the retention and distinct advantages of the skilled and existing workforce. I'm pleased that Dr. Singh is talking about doing so at the sites where Holtec is working. Using that existing labor workforce is so important because they know where all the problems are, where there aren't problems, the idiosyncrasies of each plant. Waiting decades to move on that cleanup harms communities and the larger state interests, while also losing the significant advantage of that workforce. And finally, in our written statement that we've submitted for the record, we briefly discussed the constructive prescriptions that were laid out by NRC Commissioner Barron that would ensure the adequate funds, resources are available when necessary for the cleanup. And one of the things that I want to stress is Commissioner Barron suggested departing from the generic surety formula, the generic financial assurance formula, so you can actually look at the community beforehand. By the way, this is also part of the hearing rights that should happen beforehand, that you can make sure that you're meeting all the needs of that community. Last thing I want to touch on, because it got brought up here, is the issue of nuclear waste and the nuclear waste that will be here in Plymouth or that will be here on the South Shore for years to come. Hopefully we can move it, but I want to say something really positively, not just because I'm sitting in front of him right now, but Senator Markey has introduced legislation that would actually take the first constructive step on nuclear waste in decades. Last fall, Senator Markey in the Senate and Representative Keating, your colleague, Congressman Levin from California, who has songs in his district. They both introduced the Nuclear Waste Task Force that would actually get to the real questions left on the table by President Obama's Blue Ribbon Commission on nuclear waste. Specifically, the Nuclear Waste Task Force, and Representative Keating, I hope we can depend on your support for this bill and getting it into law. Now, what it would do is it would just create a task force. It wouldn't change the law yet, but it would create a task force that would examine placing nuclear waste under bedrock environmental laws, removing the exemptions from the Atomic Energy Act. That sounds law reviewy and esoteric. It's not. What it would do is it would allow EPA and the states to set meaningful standards. And that's if the task force recommends this. If other people think you want to keep trying to bribe Nevada, or actually, let me be clear about something Dr. Singh said that I don't believe is entirely accurate. The state of New Mexico has not consented to receive a consolidated interim storage site and the nation's nuclear waste. In fact, they've done precisely the opposite. I have, and I can submit for the record, a letter from the governor of New Mexico that I believe would be not going out of bounds to say she ferociously objects to the receipt of the entirety of the nation's nuclear waste. I can also recommend you go talk to your colleagues from the New Mexico delegation about just this issue, and New Mexico has not consented, nor has the entire region around southeast New Mexico. There's, I can also submit for the record environmental justice groups that would like to probably weigh in on this matter. But in contrast to that, Senator Markey's Nuclear Waste Task Force would set up a process where we can hash out what consent really means. NRDC believes that bedrock environmental laws can allow for a process where a state can say no, or more importantly, yes, but on what terms and how much. So much of this can be addressed. There is a way forward on nuclear waste. Senator Markey is actually trying to put us on that way forward rather than just do the same stuff we've done over the past 60 years and failed repeatedly. So with that, I'd be happy to take questions and turn it over to my colleague from Massachusetts, I think.
Again, thank you, Mr. Fettis, very much. And now we'll hear from Senator Moran.
There we go. A little, it's like the Zoom thing. You got to keep trying it. Okay. So thank you for this unprecedented almost field hearing, Chair Markey. I want to really appreciate your recognition of the gravamen of this moment for Plymouth. Want to thank Congressman Keating for being here. Thanks Senator Warren, committee members, the members of both the Plymouth Barnstable and the Cape delegations, the residents, and the town of Plymouth, who's represented well here today. Thank you all for coming to America's hometown and the Patuxet village of the Wampanoag tribe. I also want to thank Senator Sear and Rep. Peake for their participation. Here's the state senator representing many of the communities that are impacted by the Holtec Pilgrim Power Plant. My colleagues, including the entire delegation of Sear, O'Connor, Peake, Muratori, Fernandez, Lenatra, Cutler, Xaros, Diggs, Vieira, and Whalen. And I've been working diligently fielding concerns for our constituents. I hope that our concerns will be incorporated into decommissioning practices to protect the long-term health, safety, and economic success of the communities we serve. The way we handle the safe closing of this nuclear power plant will set a precedent for others throughout the country. We have a unique opportunity to examine the shortfalls of this situation and set guidelines and expectations for others to follow. As you know, the nuclear reactor at Plymouth Nuclear Power Station shut down May 31st, 2019. That August, Holtec acquired Pilgrim after the Nuclear Regulatory Commission approved the transfer of the plant's license. Shortly thereafter, the Massachusetts Attorney General filed a lawsuit out of concern that funding deficits based on Holtec's decommissioning cost estimate proposal and insufficient funding in the decommissioning trust fund would result in possible health, safety, environmental, and financial risks to the state and residents. More broadly, the public having ongoing concerns that range from sufficient funding to proper oversight and monitoring of the decommissioned facility, Pilgrim's exemption from emergency planning and preparedness requirements, safety and security issues of dry cask storage units, and most recently, alarming statements of Holtec's plan to dump 1 million gallons of radioactive water into Cape Cod Bay. Since the license transfer, there's been a lack of transparency and opportunity for public input. This lack of communication and disregard for transparency and community involvement leads to a collective feeling of an imminent threat to residents. Unfortunately, there's been little reassurance. There's a serious incongruency in the oversight of decommissioned power plants, specifically in reference to the proposed dumping of radioactive material into Cape Cod Bay. Holtec is currently prohibited from discharging water from the site unless it receives an updated National Discharge Elimination System permit. The updated permit would require EPA oversight of pollutants in the water. However, as defined by the Clean Water Act, the term pollutants does not include radioactive material, including radioactive waste. Therefore, unless there are additional pollutants to require a denial of the permit, EPA is powerless to intervene even if the levels of radioactive waste are toxic. Oversight may then fall to NRC, which sets radioactive water discharge limits 4 times higher than the EPA recommends. Neither of these limits speak directly to the impact of cumulative discharge and their impact of marine life in Cape Cod Bay. We have a situation then where one government agency is pointing to the other and in some instances contradicting itself while the residents and advocates who are here today raise alarm. Any potential risk to the Bay is a risk to public health, the tourism industry, the commercial fishing industry, as you both have mentioned, both of which are represented here today. The risk is very real. I recently spoke with Robert Ward of Homeport, Plymouth. Mr. Ward has been fishing since he was 13 years old. He learned the craft from his father. Mr. Ward is part of the South Shore fishing industry that generates $6 to $8 million in revenue annually and is part of the chain for a successful and environmentally responsible local economy. They stock local restaurants, purchase ropes and maintenance from hardware stores in town. Mr. Ward and others in the fishing industry guard the oceans to keep them whale safe and often make profit sacrifices to maintain aquatic ecosystems. Mr. Ward expressed very clearly to me that there is a fear that dumping radioactive discharge will create a negative perception of local industry, and this will harm industry made of small businesses working on tight margins. Well, Mr. Ward is absolutely right. We still have a serious lack of understanding of what is in the potential discharge, the manner of depositing into Cape Cod Bay, and who is responsible for mandating testing. And it should be independent testing. The concentration of any chemical can be altered depending on season time that has gone by, amounts released, how the chemicals react in a different environment. That's the Woodsole Scientific information that was just mentioned. Thank you, Congressman. In the course of failing to provide this information, Holtec has allowed fear to spread and compounded the economic impact of their announcement. Frankly, the announcement of dumping material into the bay demonstrates a callous disregard for the health and livelihoods of our communities and significantly undermines public trust in Holtec's decision-making. There are few guardrails to protect our communities. This must change. In calls, emails, testimony, and rallies, our constituents are telling us loudly and clearly that they are fearful of what will happen now and for generations to come if we allow Holtec to discharge large volumes of radioactive waste into Cape Cod Bay without greater oversight and better safeguards. We have an obligation to listen and respond. Many of these subjects are further detailed in written testimony that was submitted by me and other members of the Massachusetts State Legislature representing the South Coast, Cape, and Islands, as well as directly by towns, including one I understand the selectmen have just submitted, as well as the Board of Health previously. I look forward to answering any questions you may have and continuing to collaborate to ensure the safe closure of this facility. Thank you.
And thank you, Senator Moran, very much. Thank you for your incredible leadership on these issues. And finally, we're going to hear from Mr. Seth Scofield, the Senior Appellate Counsel for the Energy and Environment Bureau of the Massachusetts Attorney General's Office, where he provides appellate advice and handles appeals and affirmative and defensive cases in federal and state court. In that capacity, he covers a wide range of state and federal administrative law, constitutional, environmental, energy, and nuclear power plant issues. So we have the state's expert here with us today, and we welcome you, sir. And whenever you're ready, please begin. Could you move the microphone just a little bit closer, please?
Okay. Can you hear me now? Okay, I'll just begin again. Senator Markey, Representative Keating, and members of the committee, thank you for holding this important hearing and for the invitation to testify today. My name is Seth Scofield. I am the Senior Appellate Counsel for the Energy and Environment Bureau in the Massachusetts Attorney General's Office. The decommissioning of a nuclear power plant is complex and expensive. The decommissioning process also poses significant safety, environmental, and economic risks to states, municipalities, and local communities. Today, I will speak briefly about the Commonwealth's experience with the Pilgrim Nuclear Power Station in Plymouth, Massachusetts, and 3 fundamental flaws with the Nuclear Regulatory Commission's proposed decommissioning rule. In short, the proposed rule does nothing to mitigate the risks associated with decommissioning nuclear power plants and totally disregards the substantial concerns consistently raised by states, the public, and NGOs. The Commonwealth has firsthand experience with decommissioning issues. We recently engaged in a lengthy and contentious process to better ensure that the Commonwealth and its residents would be protected from the risks associated with decommissioning the Pilgrim nuclear power plant. In the end, we secured a settlement agreement with Pilgrim's new owner, Holtec, to remedy shortcomings in the NRC's regulatory scheme and to create certainty about the application of important state law requirements. While we were successful, we received no help from the NRC. Instead, the NRC opposed our efforts and dismissed our concerns. The lengthy agreement covers numerous key issues, but today I will highlight 3 areas that are critically important to states: financial assurance, site restoration standards, and state agency funding for emergency planning and oversight. First, The agreement includes a robust set of financial assurance requirements. Under the agreement, Holtec must maintain certain minimum trust fund balances to ensure, among other things, that the Pilgrim site is remediated and restored for unrestricted future use. If that fund dips below those minimum balances, Holtec must replenish the fund with recoveries it obtains from the U.S. Department of Energy. Second, the agreement requires Holtec to comply with the Commonwealth's radiological and non-radiological cleanup standards. For example, Holtec must comply with the Commonwealth's significantly stricter 10 millirem per year residual radioactivity standard and remediate non-radiological contamination to a level that will allow for unrestricted future use unless doing so is technically infeasible. Third, the agreement requires Holtec to make annual payments to 2 state agencies. Those payments are intended to ensure that both agencies have sufficient funds to continue to perform their important public health, safety, and emergency planning oversight responsibilities. Over time, the annual payments step down as risks decrease. Turning to the NRC's proposed rule, the draft rule does nothing to improve the process for states, municipalities, or the public, or to address the significant risks associated with decommissioning nuclear power plants. Instead, the proposed rule makes the process easier for industry and the NRC itself. Today, I will highlight 3 ways in which the proposed rule falls far short. First, the rule proposes to maintain a hands-off approach to decommissioning the nation's aging nuclear power plants. As NRC Commissioner Barron stated, the proposed rule, quote, allows licensees to make virtually all of the major decisions, end quote, without NRC approval or meaningful public input. The approach is foreign to other environmental cleanup laws in the United States, such as the Superfund process under CERCLA. If the Commonwealth had been limited to that process, it never could have secured the critical agreement with Holtec that I described earlier. The Commonwealth's inroad was through a separate process, the license transfer process, that will not be available in all cases across the country. Second, the NRC has adopted a risky approach to decommissioning financial assurance. For example, the proposed rule does not address the NRC's routine practice of granting exemptions to licensees to use decommissioning trust funds for non-decommissioning purposes such as spent nuclear fuel costs. At Pilgrim, for example, the NRC authorized Holtec, a limited liability company with no other assets, to withdraw nearly half of Pilgrim's trust fund for spent fuel management costs without any associated reimbursement requirement. In effect, the NRC authorized Holtec to take millions in Massachusetts ratepayer money as private profit while depriving the trust fund of much-needed money. And last, the rule proposes to reduce emergency preparedness requirements before all spent nuclear fuel is removed from the spent fuel pool and safely placed in dry cask storage. The NRC's rationale is based on the false premise that 10 hours provides, quote, ample time for all plants in all scenarios to evacuate surrounding populations without the ordinary emergency preparedness requirements in place. This is a dangerous mistake. And for that reason, it is opposed by emergency planning professionals, FEMA, and states. I commend Chairman Markey and this committee and its staff for taking on this important matter. Thank you.
Thank you, Mr. Scofield, very much. And now we'll turn to questions from our witnesses. And let me begin with you, Dr. Singh, if I could. We're joined today by well-respected labor leaders representing our building trades here in Massachusetts. And I understand that there is a labor dispute currently at the facility here in Plymouth. I want you to guarantee that you're going to be meeting with all of the following unions to discuss staffing at this site and decommissioning other sites around the country, and that's the iron workers, the laborers, the carpenters, the IBEW, and operating engineers. Will you meet with these unions to resolve this issue of staffing here at this plant?
Yes, Senator, this is Chris Singh. We're committed to working with the unions. We have national agreement with most of them, and we work cooperatively with them to ensure worker health and safety and public health and safety. And I assure you that that dialogue, if any union is not already in national agreement, we'll continue to work with them to develop appropriate agreements. But we are committed to working with unions at all our sites.
So it's critically important that we resolve these labor issues, these union issues, and I thank you for your commitment to doing that work. As we discussed earlier with Dr. Lobinski, we've heard serious concerns about the impact that the release of the 1 million gallons of irradiated water could have on the region's fishing, tourism, and real estate industries whose reputations and operations rely on Cape Cod Bay's reputation for clean and safe water. We definitely have an issue that is central to the community here. Senator Moran, have you heard concerns from your constituents about the risk that dumping this water might have on the local ecosystem and economy?
Yes, I have. I think all the legislators here have heard concerns. In particular, the emergency planning zone requirements, which are the essential protection and action plan to reduce radiation exposure, shelter, and evacuation strategies. The former fire chief right here in Plymouth, Ed Bradley, had to specifically demand and negotiate continued funding. And that funding is lacking in all of the contiguous communities, as well as the communities that had previously been funded. The result here is that there is a need to divert resources, taxes, time in emergency preparedness, because I think, as all of the advocates have reminded us well over many years, these are potential airborne and ocean transmissible concerns that could travel far and wide. So that is just one example, Senator. Thank you for the question.
No, I thank you. I thank you. Dr. Singh, has Holtec looked at the issues that Mr. Fettis just raised? That is the vigorous opposition of the state of New Mexico to the siting of this facility. So you're holding out to the residents here in Massachusetts that hope should be how they view these issues. But what we're hearing from Mr. Fettis is that the likelihood of that occurring in the near term, at least, is very, very slight, given all of the political opposition that exists in New Mexico to house permanently all of the nuclear waste from Plymouth, Massachusetts.
Senator, Holtec has spent $80 million of its own money to license, develop all the systems, to establish the facility in New Mexico. The governor of New Mexico the then governor wrote a letter to the DOE secretary voicing strong support for the project in New Mexico. The local community, as I said earlier, stands 100% behind the project. There has been a change in government. The new governor appears to have a different idea, but I think that as the public gets educated statewide, I don't think the state of New Mexico, people at large, are against the project. It's all political. And I think even people, regardless of their party affiliation, when they realize that this facility will emit no particulates, it has no environmental impact to speak of, it requires hardly any water other than the water that people will consume at the site. It makes no demand on any resources. Why would they not support it beyond me?
Never, well, again, as Mr. Fettis,
So I just want you to know that I'm a firm believer that ultimately reason and logic prevail, regardless of the political winds at a particular time. We started this project years ago. The governor was in strong support. So was most of the political establishment, and the public has always been.
well, I'm just going to restate what Mr. Fettis says, which is that this governor is ferociously objecting to the operations. Is that correct, Mr. Fettis?
And I respectfully disagree with that. If the governor had really been so vociferously, as it put, against it, then the bill would have come to her, just like Texas banned the spent fuel facility in their state. New Mexico could have done that too, but they did not. So I don't think their opposition is vociferous. I don't think their opposition is obdurate. I think that they're waiting to learn more, and then they'll make their decision.
Okay, Mr. Fettis.
I'd like to respond briefly.
please.
Thank you, Senator. Couple of things. One, the state of Texas, which has as we all know probably in this room, a Republican governor and Republican-dominated legislature, has also objected to hosting the nation's consolidated interim fuel. The entire, there's a similar license afoot in Texas, which has elicited red state objection, whereas New Mexico, which is now a blue state with a Democratic governor, has also significant objection. So I would suggest that objection remains bipartisan, just as it has in Nevada. And one thing I'd like to quickly address, if I can have your forbearance for a moment, is there's always this reductive language that it's just politics and we have to get past the politics. Well, I really bristle at that because politics is how we decide things by not having land wars in Europe. Politics is really important because it's how we decide our institutional questions of who gets to decide and on what terms. And that's why we're here today, and that's why we so appreciate you doing this.
And I appreciate that too, because this is my 45th year in Congress, and I served on the nuclear subcommittee for 45 years. So no one has ever done this before in congressional history. So I remember back in the middle of the 80s, when the National Academy of Sciences, for example, had a set of recommendations, but yet the decision was political, that they were going to stick the people in Nevada with the nuclear waste site at Yucca Mountain, even though it had an earthquake fault nearby, even though it had a river nearby. And obviously, the questions that were being raised are still the questions being raised today. So I think that we should operate under the premise for today and for the foreseeable future that this spent fuel will be on location here. And as a result, what are we going to do about it? How are we going to handle this issue? It's 45 years that I've been dealing with the issue, and my expectation is that it's going to continue for an indefinite period of time. So I would ask you, Dr. Singh, has Holtec ever conducted an economic and environmental analysis of the impacts of spent fuel pool discharges to the marine environment in Cape Cod Bay?
Yes, I would. As I said earlier, we did study the effect of discharge in Cape Cod Bay under a contract with the utility at the time, Boston Edison. But I'd like to answer the first part of your question, Senator, if I have your forgiveness.
Well, it was not a question, it was just an observation, okay? The point that I'm trying to make is that we should just deal with this as though it is a permanent problem.
I see.
And to put permanent solutions, protections for the people here in place. And maybe there is someday in the future when the problem does get solved on a permanent basis in another state, but I prefer just to deal with it as something that's urgent. And now, because I had my first meeting on the Pilgrim plant in 1979, and it's now 2022. And while I would hope that it could be resolved, I just want to ask you the questions about resolving the issues today, Doctor. So why haven't the relevant marine sanctuary experts and local stakeholders seen the documents? Why are they still in the dark?
Yeah, let me answer the question fulsomely, Senator, but I would like to simply get in the record that I don't think our country should give up on an interim storage facility. Even Ukraine, threatened by Russia, has now a facility up and running. It is a pity that we cannot get in this country a storage facility together. And I should just add one sentence. You cannot, no one can point to a single environmental impact that this facility would have on the host community. It's all emotion, no logic. And whether it's bipartisan or single partisan, the point is it should be logic-based. It should be region-based. And why this country can get together and establish a facility beats me. And people in overseas, other countries wonder what's going on in America.
And again, people are responding emotionally because they feel they don't have all the information they need. They feel that there's a process that has been truncated, that all of the questions that they are asking because of their own family's health and safety have not been answered. So that's what Mr. Scofield, that's what Mr. Fettis are talking about here today. That's what Congressman Keating and I have been asking about. Why can't there be a more thorough, inclusive process that gets the answers in a timely fashion, but in a way that does not leave a cloud over the answers that are finally given to the public, because they sit out there saying, I don't think my family is being protected. So from, again, in terms of my question, not having the relevant marine sanctuary experts and local stakeholders see the documents is something that obviously, because of the whole history of nuclear power in our country, just in their minds raises questions about whether or not they're getting the truth, whether they are actually getting all the answers which they want. So that's why this process is so important. That's why I'm here having this hearing, so that they can get the answers. And if they don't get the answers today, that they get the answers before there is any dumping of radioactive water into Cape Cod Bay. They deserve all of the answers to have been answered thoroughly. So do you understand why the public has questions about Holtec? Can you understand why that's the case, Mr. Singh?
I suppose I understand, Senator, but let me answer your question directly first. In the work Holtec had done roughly 20 years ago on water dispersion in the Cape Cod Bay, I think the file is still available, and I'll share with any expert that you would nominate to look at it. We had done studies on how water diffuses in the bay over 20 years ago. The region, it does not raise concern amongst people who are knowledgeable in the subject matter, is, as I said before, the level of radioactivity is a factor of 800, more than 800 less than what NRC considers admissible. It's below a factor of 200 below what EPA considers acceptable from nuclear plant operations. It is difficult to stir your engineers and scientists, whether it's a marine biologist or whatever to look at the data and say that there is a risk. But of course, if in the media, if this gets trumpeted as a concern, yeah, I think that the image of the community calling the water, which is processed water, contaminated water, and if it's said over and over again, it becomes contaminated water in the minds of the people. So I don't know what we do. You know, because of these challenges, we basically stop. We said, okay, we'll let the water just sit there. And when we all become science-focused, science-based, then we will discharge it. There is, of course, an alternative. We can ship the water to someplace else where it can be discharged. But let me ask you this. The amount of water in the world is finite, it's not changing. And taken from one place to another, does it solve the problem? Really doesn't. We got to make sure the water is clean and meets the limit in the first place. And as I said, it meets not by a factor of 2 or 10, by a factor of hundreds. It is clean. It's not contaminated water. But we would not discharge it until we have consent from our stakeholders.
Okay,
We will
so-
not discharge it because we do not want to upset anyone. Let me just close with one comment. In a closing plant, the amount of interaction with the bay is a minute fraction of that what was occurring when the plant was running, when it was operating. We were discharging water, of course, in the bay when the plant was operating. And look at the quantities. Today, it's a dead plant. There is hardly any discharge. And yet, the community welcomed it, supported it. There was no talk of contaminated water in the bay back then when the plant was running. So I really don't get it. Perhaps folks can enlighten me. Why today there is a new concern about water that is orders of magnitude below level where it could be called contaminated.
Okay, so I think for everyone here today, you just said something very important to them, which is that you said we will not discharge the water unless you have the consent of the stakeholders. Is that what you just said, Doctor?
Yes, I said the stakeholders, I mean the state, the state, the NRC, the people who we routinely, EPA, we consult with to do anything. And because this item has become one of political, had taken a political dimension, no, we will not discharge without getting.
So when you say stakeholders, do you mean the state of Massachusetts, the attorneys general, the attorney general's office,
It's your office, Senator? Yes.
and my office? All
In
right.
any organization any organized group that.
And the people of Plymouth.
We will consult.
Yeah.
We'll consult. We participate in NDCAP meetings, as you know, routinely. Look, we try to be as transparent as possible. I really don't understand why people say we keep information. We put information on our website. We publish routinely. We publish bulletins. You can go on our website and see questions and answers to decommissioning issues. We are not a closed company. The people who work for us are residents. They're your neighbors in Plymouth and surrounding towns. We don't have people from out of state, that many of them, only a few. It's the local people who are doing it, using our methods and processes. We are not, the workforce is not alien to your community. I really don't know please tell us how we can improve communications. We are all ears. We want to be the very best neighbor.
Well, you can hear from the state of Massachusetts, from the Attorney General office, how concerned they have been about the process, about the need for them to actively intervene in order to get answers. So that leads to a suspicion, that something is being hidden, that the information is not being fully transmitted. So I understand that Holtec is looking at other alternatives beyond dumping the water, including evaporation or trucking. but has the company considered storing the radioactive water on site, giving the radioactive isotopes in the water time to decay before the water is disposed of?
Yes, we will. There are pros and cons. You know, in any decision you make, there are pros and cons. If we ship it from the site, we're going to burn diesel fuel. That's a emission in the environment. It will go to another place, but there is a clear, definite negative that should not be overlooked. If we let it sit, which we will, if that's what the stakeholders tell us, you don't discharge water. I don't like the term dump because it's not a dump. It's a discharging it to the bay with under prescribed conditions in a controlled way. But if the decision is to leave the facility standing and leave the water there, we will do that. But our goal, we think the best thing for the community, for the state of Massachusetts, is to get all contamination out of there and clean the place so it can be repurposed, it can be redeveloped. That's what we thought would be most agreeable to the local community.
Okay,
But if you'd rather keep the water there, we'll keep the water there.
So the NRC and Holtec contend that the proposal to dump the 1 million gallons of radioactive water into Cape Cod Bay is safe. I know that the communities would feel a lot safer if an independent body with fisheries expertise was able to confirm that the types of radionuclides in the water and their concentrations were in fact safe for our region's fish and shellfish. Dr. Singh, once the spent fuel pool water is ready to be sampled, will Holtec commit to, one, having an independent body with fisheries expertise such as, and you talked about this incredible expertise which we have in Massachusetts in science, well, we have the #1 location in the entire world, and it's here on Cape Cod, the Woods Hole Oceanographic Institution. Would you agree to have them test and evaluate the sample and to agree not to release the 1 million gallons of radioactive water into the bay unless it is confirmed safe for our region's fisheries by Woods Hole Oceanographic?
Yes, Senator, the answer is yes, and it's beyond them. If you have any other expert scientific organization, not political organization, yes, we will share with them any information we have. We'll give them access to the data at the plant to help comfort the community, because there's been so much now material in the media that it's now a non-problem, in my personal humble opinion, has become a big problem. So we have to, I think your suggestion to have experts review and study it is a great suggestion, and we will support it wholeheartedly.
Okay, well, I think it's very important that Woods Hole Oceanographic Institute be a part of this process. They have the most knowledge about this body of water of any institution in the world, and they're right here. So we will be taking you at your word and having them be included in this process. So let me turn and now recognize Congressman Keating.
Thank you, Mr. Chairman, and thank all our witnesses. I will say at the outset that it's just a common refrain these days to blame the media and just say, well, this is the media. I just want to, for Dr. Singh's purposes, tell you what everyone in our office, I'm not part of the media. Senator Moran's not part of the media. The Attorney General's office is not part of the media. Senator Markey's office is not part of the media. And the groups here that came together are not part of the media. The local officials, the lobstering community, the fishing community, the aquaculture community, the tourism community, they're not part of the media. These are real concerns. It's not manufactured by the media. It's real. I want to say that at the outset. I want to agree with Senator Moran, too, that our office has had many of the same concerns and shared those concerns among her office and the group of state legislators and local officials, our colleagues in state government that are here present. Thank you for their presence here today. I also want to emphasize, too, that the people that are working during this decommissioning, it's not simply a labor issue, it's a safety issue. And those people are necessary for this to be done safely and securely. And I urge you not just to discuss with them, but to resolve any differences that might be there. In terms of Mr. Fettis, just for the record, I am a co-sponsor of the Nuclear Waste Task Force bill, just to clear that up as well. Now, I just want to deal with a pretty important issue during this process, and that's one that Holtec has promised that the people and this community, our elected officials, and have promised a transparent process. And thus far, that's still, generously speaking, a work in progress in that regard. Because I recall back in November at a meeting of the Commonwealth of Massachusetts Nuclear Decommissioning Citizens Advisory Panel that Holtec repeated several times that the company has not made any definitive plan to dispose of spent fuel pool liquid. However, just weeks later, when our office contacted the NRC, we learned that Holtec had disclosed to them that it was planning to discharge or dump, call it what you will, into the bay in the first quarter of October of this year. And that raises issues and my concerns ongoing regarding transparency in that regard. Now, Dr. Singh, on January 22nd of this year, Holtec issued a public letter responding to our community concerns about the discharge of spent fuel coolant pool into Cape Cod Bay. And in that letter, your company expressed that they have no need to seek additional regulatory clearance from the NRC or any other agency to release the contents of the spent fuel coolant pool. On March 14th of this year, the Environmental Protection Agency sent a response to that letter outlining their concerns with the discharge of fluid from the spent fuel coolant pool, which states unequivocally that your company must seek clearance, from the EPA for any discharge into Cape Cod Bay from the spent fuel coolant pool. Has your company responded to the EPA's letter?
Congressman Keating, I don't have personal knowledge whether we have answered or not, but let me.
You are
address
the CEO, sir.
Let me ask you a question. I'll have
Under
to
the
get the
president, sir.
information for
And
you.
CEO.
A bigger question that you
Who
said
does
is
like
that
that?
we are not communicating with your office and other major stakeholders in the process, and I will rectify that problem immediately. Okay,
Well,
there is no agenda here to hold back any information.
No, I just was,
We'll fix that.
if I
We'll
may.
fix that.
Doctor, if I may, I just was struck by your comment that just a few moments ago, that you communicate routinely with the EPA and other groups. And if they sent you that request almost 2 months ago, and I'll give you the answer to the letter, to my question. I just wanted to confirm if anything happened in the interim. But the answer is no. You have not responded to EPA on this,
And if we have not, we will provide the response. But let me address the root
If I could, no,
matter.
I'm asking the questions, Doctor, if I could, because time is precious, and I apologize.
I have to give you
don't
the
wanna drift
answer.
into other
If I don't
areas.
give you the answer, you will have the misconception.
You just gave me the
I'm
answer
trying
to
to
my
tell you,
question.
I'm trying to tell you, unless the water is contaminated and it exceeds EPA limits or NRC's limits, typically, if our process does not require notifying them, then we would not. Now, being that it has become a high-profile item, we will start
No, sir.
notifying everybody. You tell us who, and we'll notify everybody.
Yeah, you are
are
going back to my
We have
initial
no
remarks. I'm going to
intention
interrupt
hide
you
any
because
information.
your premise is wrong. May I? You're saying until it becomes a high-profile item, you don't
We follow the
inform these
laws.
agencies. They are requesting from you that information. And who decides if it's a high priority item? The media
Congressman,
you're so
please,
worried about?
Please.
I don't want to be
please.
contentious anymore because I want to just
No, no, I'm
get
not-
to some
I'm
points.
just
I'm
telling you
very
how it
pleased
works in
to,
the industry,
um,
telling you how it works. If there are laws, we follow the laws.
I know how your industry works, sir. That's the issue here. I want to do this. Now, I gave you the answer to that question. I'm so pleased, and thank you very much for your cooperation in responding to the EPA's letter. We have been in touch with them. There are concerns. They have concerns, and they certainly are in a position to vent those concerns and to get answers, something that the NRC seems limited or unwilling to do in this regard. So I'm anxious to get the response from that. I have another question,
considered
if I
done.
could.
Consider it done.
Thank
It
you,
will be
sir.
done.
Thank you. I like that. So let's see if we can continue with this. Could you just give us, as the CEO and president, the estimated cost that would be entailed to transporting those wastes, those radioactive materials from Plymouth by truck, similar to the way that it was done with Vermont Yankee?
I don't know where Yankee shipped it, but trucking.
Could you just share with us your estimate for what that cost would be if you're considering viable alternatives?
Get you the cost. We'll get you the cost, but please understand, to us, that's a poor solution.
Well,
Burning diesel fuel to take water from place A to place B is.
I'm so glad.
to
I'm so,
me, But we will
Sir,
give you the cost.
do you have electric, by the way, just you brought it, do you have electric vehicle? Are all your vehicles that you have in your company electric, by the way?
Some are, not all.
Some aren't. Well,
Yeah.
be
Yes.
concerned about that with diesel fuel. Be concerned about that if
Yeah,
you're so concerned. I just,
Things that electric vehicles don't have environmental baggage needs to do some more learning.
okay. So if you could, you haven't even estimated what the cost of that alternative would be. So that makes me question how viable or how serious you are about looking at these alternatives. Can you understand how I would have that concern?
Congressman, you can entertain.
I'm not
and draw any
entertaining.
conclusions. We follow the law. We do not ever allow anyone to break the law, and we are transparent. Now, trucking on the face of it is a poor solution in our opinion. But if you think we should give you the cost that will help enlighten the issue, we will do that. We also we can locally evaporate the water using electric heaters. That is environmentally bad as well. And do all that when the water purity level is so high. You may or may not know, Admiral Rickover, who ran the submarine fleet in the US for a long, long time, he was challenged on this issue. And he brought a glass of water to one of the hearings in Congress and drank it, that processed water. That's how good it is. So it's any item can be made into a major deal, but in my opinion, it is not a big deal. And the scientists that the senator has proposed should look at the data. I am sure they will corroborate our position.
Well, there's a room full of people here that aren't drinking the water on that answer. But
I won't next
it's much more complex than that. And that's why the EPA is concerned about that and why it's important to find out if there's mixtures. Is anything amusing I'm saying, sir? If there's mixtures that are there. There's concerns on boron and other heavy metal mixtures. These things should be done in the introductory level, not afterwards. And we should have answers to those things, as well as answers to the viable alternatives that exist as well. We hope we can continue, perhaps, with these questions. At this juncture, I'll yield back, Mr. Chairman.
Thank you. Let me turn to you, Mrs. Scofield. Mrs. Scofield, you mentioned in your testimony that you worked on a settlement that was released in June of 2020 between the Massachusetts Attorney General's Office and Holtec which secured critical environmental, public safety, financial protections for Massachusetts residents. And I thank you for your work in defending the interests of Massachusetts residents from potential corporate malfeasance, as well as from neglect of federal agencies. Mr. Scofield, if Massachusetts did not file suit against Holtec and the NRC's move to transfer the license for Pilgrim from Entergy to Holtec, would the state of Massachusetts have been able to weigh in at all on the decommissioning process?
The Commonwealth would not have been able to weigh in a meaningful way. We could, of course, submit written comments on the PSDAR, but as we've heard today, that's really an illusory process. It's not meaningful. The NRC doesn't approve it. There's no opportunity to challenge that document. Frankly, it's hard to even understand what the plan is from the PSDAR because of the lack of detail. Correct.
So if there is a decommissioning that's going to be going on around the country, let's just say Seabrook, but the company keeps ownership of that plant, there is no avenue in for New Hampshire or Massachusetts in terms of how that decommissioning is being conducted. Is that correct?
I don't want to concede.
Okay, yeah, I appreciate that. I think
very difficult.
it would be very difficult. Thank you. Mr. Scofield, what issues were you able to push Holtec to discuss and commit through the settlement that the NRC's rulemaking and agency process failed to ensure was included in the Pilgrim decommissioning plan?
I think I'd like to highlight one today, and that's the financial assurance component of the settlement agreement. I won't go into all of those details today. It's technical, long. There are multiple layers, but I think the most significant piece of the settlement, at least from the Commonwealth's perspective, in terms of ensuring sufficient funds going forward, both for restoration of the plant and also for managing the spent fuel on site, were the establishment of these minimum balances that Holtec must maintain in the trust fund. The NRC doesn't have a requirement like that. We have now set in our agreement a minimum fund, which is based on input we received from our consultants, that would be a minimum amount necessary to allow the project to go forward if they started to run out.
So again, you're saying the NRC does not have a minimum balance which the company has to keep in order to make sure that the project is successfully completed, but because of your intervention here in Massachusetts, we are setting a precedent that there is a minimum balance and that the funding is there and that it's guaranteed so that the state, the residents in proximity of the plant are not left with the ability to be guaranteed that the process of decommissioning comes to a successful conclusion. The funding will be there in Massachusetts, but it's not going to be there in the rest of the country because the NRC does not require that in the rest of the country. Is that correct?
There's a much higher risk that it won't be, that they will run into issues. And what we've seen over and over again is that the cost of decommissioning power plants significantly exceed the NRC's site-specific cost estimate for these plants. So that going into this process made us extremely concerned and hyper-focused on this issue. The other piece of this that I think is important to note is the exemption process for using spent fuel, the decommissioning trust fund money for spent fuel costs. Of course, it's very important to have money to pay for the management of spent fuel on site, but the NRC is granting exemptions to use decommissioning trust funds, funds that its rules categorically prohibit from being used as for spent fuel costs, for spent fuel management costs, which are then recoverable in subsequent lawsuits by the licensees from the DOE.
Okay, so if I may, because I just want to put this out there so that everyone can understand the great job you did, the Attorney General did, in setting this precedent, because when Holtec bought Pilgrim from Entergy, it bought $1 billion decommissioning trust fund that ratepayers had been paying for decades. The people in this room have been paying for decades into that trust fund to create that $1 billion. And the settlement agreement between your office and Holtec stipulates that the decommissioning trust fund must be at least worth $193 million once the site is ready for partial release. Mr. Scofield, what happens if the trust fund runs out of money and neither Holtec Decommissioning International, Mr. Singh, its subsidiaries, nor its parent company have the funds to meet those financial thresholds and they declare bankruptcy? Who is left to foot the bill for the rest of the plant cleanup process?
Well, the Commonwealth's fear has always been that it would be left to the states to pick up the tab and ensure the sites are cleaned up.
Would you pursue legal action then against the company if that happened?
Of course, we would pursue that action, but in my past, I did much more of this as an enforcement attorney. I have experience trying to pursue companies that have no assets, no property, or in bankruptcy. It is extremely difficult.
Mr. Scofield, on the flip side, what protections are there to ensure that Holtec doesn't cut corners to do the lowest cost decommissioning possible in order to take home as much as possible of the ratepayers' built $1 billion trust fund?
Well, there are few different things. One, we established a framework in the settlement agreement that we believe will help mitigate the risk of that. First, by establishing clear guidelines as to what the compliance standards are for the site. And importantly, those compliance standards are to allow for unrestricted future use of the site based on compliance with more restrictive state law standards. We also have our state agencies are heavily involved, our partners in this process, and they are doing frequent inspections of the site. I know Dr. Singh indicated that the company should be given an A+, and they wouldn't do anything to violate the law. But there actually have been some violations of state law in the process so far. They have not been major issues, but there have been some asbestos issues. There was a water discharge issue and a wastewater issue as well. So there are issues, but fortunately we have a great team with our state partners, and they are out there monitoring and making sure that to the best of their ability that the public is protected and that the laws are complied with.
Okay, good. You're depending on the monitoring that you're going to be doing, okay? And that's why I feel good here, because we're depending upon your great work and the state's great work to keep a financial eye on the plant. So where is the NRC on this issue of financial responsibility and protecting the ratepayers? And if that doesn't actually turn out to be sufficient, the taxpayers of Massachusetts, who would ultimately have to be the guarantor of the safety here at the plant.
I'm sorry, Senator. The question is, I missed.
What is the role of the NRC? What is the role of the NRC?
The role of the NRC should be
but
very
is it?
Close eye on all of these matters.
And how good of a job does it do?
But in our experience, they're not.
They are not.
And to the point where the Attorney General's office, for example, has continued to retain an expert on hand even after the completion of the settlement, so that we have additional financial expertise for monitoring the expenses that are going on at the project to see if, ahead of time, we're trying to see before the car hits the wall, we want to know that we're getting close to it. So we're watching that very closely so that we can try to get ahead of it.
Okay, so the proposed decommissioning rule doesn't allow the decommissioning trust fund to be used for spent fuel management, despite the initial argument from NRC staff that it should. But it does still allow plants to petition for an exemption and use the trust fund for spent fuel management, which Holtec has already done. If operators get this exemption, they can use the trust fund to manage spent fuel, get reimbursed for that management from DOE, and walk away with the money. So Mr. Fettis, can you follow up here? Do you agree that these exemptions are dangerous and allow for money to be siphoned off from ratepayer-funded trust funds and into company coffers?
You described it accurately, Senator. It's a problem, and there is a prescription in Commissioner Barron's dissenting vote on the draft rule that could address a lot of your concerns. If the NRC withdraws its rule and follows that prescription, many of your concerns and the concerns of the folks here in Plymouth can be alleviated.
Okay, great. So, Dr. Singh, is Holtec planning to sue the Department of Energy for spent fuel management reimbursement, even if it uses the decommissioning trust fund for spent fuel management?
There is a misconception here, and I think your discussion is going on the wrong track. Please forgive me for saying this. The NRC does have a decommissioning cost estimate requirement that at the end of each year, we provide to the NRC, which gives all accomplishments that had occurred already and what remains, and the estimate to finish the work. And NRC makes an independent evaluation whether the funds are adequate. And if the funds were not adequate, then we are required to put money from our company's general funds into decommissioning fund. As a matter of fact, because the market value has come down recently, as we all know, and we are doing the settlement on Palisades in less than 60 days, there is a likelihood that we will have to add to the fund a $20 or more million to bring it up to NRC's requirements. So there is a process there. The state of Massachusetts is being more proactive and has placed additional requirements, and we agreed to it. And we have, we are, by the way, we are not a limited liability company with no assets. Our assets are north of $4 billion. So we are not a weak counterparty, and we have been profitable in every year of our existence for the past 36 years. So there is no risk of the company going bankrupt and not finishing the job. We are finishing the job ahead of schedule, as I told you earlier.
Well, what I've found over the years, Dr. Singh, is that you may be making personal commitments right now. Don't worry about it. But if you're gone and somebody else takes over, and they've gone to a business school with a pretty simple 3-point plan about how to max out for your company, they're not bound by anything you're saying right now. So the reason we need rules, the reason we need protections in place that are guaranteed is not your 36-year track record, but rather what's going to happen 36 years from now. What are the guarantees? So, Mr. Scofield and Mr. Fettis, do you want to talk about that? Dr. Singh said we're on the wrong track with this whole conversation. Do you agree with him?
I don't agree with him. I mean, it was interesting what he just said, because what I think he was saying was that the parent organization, what he was saying today was agreeing that they would take responsibility for any future shortfalls. So that's very interesting and very helpful if that's accurate, because the structure is that Holtec International, a parent entity, they do have a lot of finances, but they're not the licensee at the site. They're not legally responsible for what happens at the site. The entities that are legally responsible for what happens at the site are 2 LLCs. They're the licensees, and the only asset those licensees have is the trust fund. So hence, that's a big source of our risk. And this is the first time I've heard from Dr. Singh of a commitment by the parent company to essentially guarantee the work of the LLC. So I appreciate that commitment.
Yes, and I'll reiterate that Holtec International will stand behind the commitments made by its operating subsidiaries.
Okay.
Absolutely. Look, the damage to us reputationally would be enormous if we walked away from a project without finishing it. It's just not money. Our company has enormous goodwill and value, reputational worth in the world marketplace. We cannot afford to, for one project, maybe cost us $100 million, we will not walk away, absolutely not. And I don't think any future CEO of the company would either. This company has an enormous value as an enterprise that is trusted around the world. We did Chernobyl, you may or may not know, we did Chernobyl nuclear plant. And that was considered an impossible job. And we finished it. We turned the keys over to the Ukrainian government. We have too much to lose to fail at any site and not complete the project. Please understand that.
Okay. And if you get reimbursed for the cost of spent fuel management, will you commit right now to ensuring that this money is returned to the trust fund and used to support cleanup of the site?
Cleanup of the site is an undivided responsibility of OTEC. How the books are done, I can't tell you, but the decommissioning cost estimate, if the cleanup and the fuel cost was in there, and I can't tell you, I don't look at the books in that level of detail, then it will be returned to the decommissioning trust fund. If it is already factored, then it won't be. But at the end of the day, each activity has an associated cost, and we must, our accounting people, they keep track of progress of the project against the accomplishments made. And we are under federal law required to report it to the US government, to the NRC. So if we are overrunning the charges and we are above the estimate, then yes, I think NRC will ask us to put more money in the fund. And that is the club they have. And I'm glad they have the controls because it is necessary. It is necessary that the people, the communities are protected. And I believe the rules are in place to protect. Now, you can always make it more strict like Massachusetts has done by requiring us to have, I think, 193 million, as you said, and the money must be in the account until we get to a certain point in completion of decommissioning. We accepted it because it's a non-issue for us. This company will never fail to fulfill its contractual obligation. That is a commitment from me, and I'm the founder. And no matter what happens down the road, we will not ever breach our obligation to the counterparties, in this case, the state of Massachusetts and any other entity.
And that is very important because obviously you have created multiple limited liability companies, subsidiaries that are each responsible for different plants, and the only asset is the taxpayer's account. So it's very important that we have an understanding that the parent company will accept full responsibility. And I don't know, Mrs. Scofield, if there's some way in which we can formalize that, but I think it would be an important, as much as I do believe in the sanctity of Senate hearings, to have a legal document that accompanies the verbal assurances from Mr. Singh, I think will be very important for the people of Plymouth to hear.
If it doesn't already exist, we'll provide the guarantee.
That is, thank you. That is a very important statement for you to make. And I see Mr. Fettis would like to add something. The microphone.
Of this. The NRC can take a much more firm and clear step by allowing the decommissioning trust fund assets, if they're going to be used for spent fuel management, to only do so if there's a projected surplus, and with whatever is used must be returned into fund.
Maybe switch mics?
No, yours is not working.
Now mine's not working, sorry. I would memorialize this as forthwith. Good luck, Seth. And if decommissioning and the NRC can make a very positive and constructive step in a new draft rule that would allow decommissioning trust funds, if they are to be used for spent fuel management, only if there's a projected surplus, and whenever and whatever is used is returned to the fund within an allotted time. And that would clarify the rules that would put in place and alleviate the concerns that Mr. Markey is making so clear today.
Mr. Yeah,
I'd
Mr.
just like
Scofield.
to add one thing. I think what Mr. Fettis just described is it's an extremely simple fix. And that really would fix this issue is if the NRC is going to grant an exemption or if they're going to promulgate a rule that allows decommissioning trust funds to be used for spent fuel management costs, if there is a surplus, as Mr. Fettis said, that they simply require the recoveries to be returned to the trust fund and not put into the pockets of the private company. Those are ratepayer funds. They were put there to clean up the power plant. They should not be, they should not be able to divert the money in that way.
Okay, so, yeah, please, Dr. Singh.
Make a comment, please. You know, we forget. We as a company go take the risk. No one else stepped up to decommission Pilgrim. Entergy executed a bid tender, and at the end of the day, we were the only ones left standing to take all the liabilities and do it. Now, when we do it, our liability is to finish the job for the money. And if we run into any problems, we don't have Uncle Sam to help us. We have to do it with our own resources. And yes, if the fuel project is done, we submit it to DOE, we expect DOE to pay for it. That fund is available to us for running our business. It is, if we run over, the same business, same parent, as I told you earlier, provides the money to the fund to finish it. So it's a logical, simple way. If you tell companies, if you have a profit, give it to me, and if you have a loss, sorry, Charlie, it's your problem. It won't work. That is not American way. So right now, the way it is set up makes perfect sense. No one has defaulted in doing decommissioning projects. We have done so many of them, as John Lobinski told you. No one has done. So why fix something that isn't broken?
So, so I think we're ready for Mr. Scofield and Mr. Fettis to figure out how to formalize this and set a precedent that the NRC will be following. I think that's going to be a big change that that we can move forward with and say to the NRC, this is where we should. Mr. Scofield, I see you leaning in to say something.
I think in terms of the DOE recoveries, if it makes total sense.
Total sense.
And that's what we've memorialized in our settlement agreement, essentially, is that if they do hit those minimum balances, they have to reimburse the fund with the recoveries from DOE. So we actually struck somewhat of a middle ground in negotiations where they don't have to put all the recoveries back in, which is our preferred outcome, but they do have to put them back in if they dip below the minimum.
It makes total sense, but we're talking about the Nuclear Regulatory Commission. So, so that's why we have to make sure that we put common sense into the regulatory framework in order to protect here the ratepayers, but also the safety and well-being of the citizens of Plymouth. And so I'll turn it back over to Congressman Keating, but I will say, Dr. Singh, I appreciate your committing to let the Woods Hole Oceanographic Institute make a recommendation on whether or not the water is safe, because I appreciate the understanding that public safety should be backed up by public science, and that is, in fact, Woods Hole Oceanographic in terms of this community. And I appreciate the movement that you've made in guaranteeing that this financial commitment is absolutely legally solid. So let me turn and recognize Congressman Keating.
Thank you again, Mr. Chairman. You know, the hour is getting late, and I just think in terms of refocusing on a very important part of this, I'd like to give Mr. Fettis the opportunity just to You said something earlier that was very important, almost ominous, when you said that this rule is really the last good chance to get it right. And in terms of that, could you just amplify on why it's so important and why, timing-wise, this is, in your words, the last good chance to get it right? Because the other side of that is we'll never get it right unless we do it this way too. So if you could, and that'll be my closing question, beautiful Mr. Chairman.
Thank you for the question, Congressman. You are deeply familiar with your years of work with how long it takes to get something serious done in Washington, D.C. that will have impact around the country. And the NRC has last revisited this, I think, 1996, Seth? Is that about right?
1996.
1996. It's 2022. That bookends my entire adult professional career. And I think it likely that something of this magnitude will take another set of years, if anything, to come up. And during that time frame, we may have the retirement of a few reactors. We may have the retirement of dozens. Who knows? There's a whole host of questions that go to economics, markets, safety, and a whole bunch of other things that will play into that. And I don't have a crystal ball, and neither do you. But we have an opportunity with the draft rule, after many years of work, to get it right and do it right now and set the ground rules going forward for dozens of sites around the country. And what Seth described, what Massachusetts had to do to protect the Commonwealth, was just extraordinary. And the fact that they had one avenue in to get traction legally. I speak as a litigating attorney. I do this, but I also litigate in courts. What they did should be lauded, and it also shouldn't have to have been done. And it was. And we have a chance to rectify that now. And unfortunately, the draft rule doesn't do that. And I think it would be a terrible loss with how complicated and serious the questions are. I mean, when you run a congressional office, your staff drinks from a fire hose, dozens of issues every day, dealing with everything from the quietest issues in your constituencies to the biggest issues of national importance and everything in between. And when you have a chance to do these big things, like a rule that sets the rules of the road for 60-plus sites around the country in a billion-dollar industry with a waste that lasts for 1,000,000 years, we should do it right. And this is that opportunity, and let's not miss it. So if it takes a few more months to withdraw the rule and reissue one that's a heck of a lot better, let's do that.
And I thank you for that, Mr. Fettis, and I'm going to be organizing, obviously, my Senate colleagues to send that message to the Nuclear Regulatory Commission, that that is how the new rules should be drafted. And this hearing has been extremely helpful in establishing what is necessary to happen. And Dr. Singh, back in 1986, I was the chairman in the House of Representatives over the Nuclear Regulatory Commission, and Nunzio Palladino, long before your time, was the chairman of the Nuclear Regulatory Commission, and we were at the end of a long hearing. And I love long nuclear safety hearings, by the way. I mean, I've done hundreds of them. So at the end of the hearing, Doctor, I said to the chairman of the Nuclear Regulatory Commission, what are the least safe nuclear power plants in the United States? And he looked at me and he said, well, of course, Pilgrim in Massachusetts is at the top of the list. And that was a big moment up here in Massachusetts. It led to a complete revision of how everyone viewed how safe this plant was and Seabrook was. But this plant then underwent a complete overhaul in terms of management and oversight. And that's really why we're having this hearing, Dr. Singh. It's to just have the public discussion, ask the questions that the public have posed, and make sure they get the answers, but also to make sure the Nuclear Regulatory Commission takes the actions that are necessary. So, if I may, the NRC granted an exemption to Pilgrim from emergency preparedness and planning requirements in September of 2019, before all Pilgrim spent fuel was even moved into dry cask storage. Some of the communities around here made agreements, lost hundreds of thousands of dollars in emergency planning and preparedness support. And also, Pilgrim no longer had to maintain emergency response capabilities or procedures for public notification. So, Dr. Singh, did that exemption allow Holtec to stop providing funds for radiological emergency training for local first responders?
You know, the emergency training, we have Holtec Safety International, the Security International, they do all that for us. The emergency planning, emergency response, this is very heavily regulated by the NRC. And we follow the regulations. Our entire structure working with the NRC is based on, they set the regulation and we follow them. And wherever possible, we try to exceed what the government requires. Now, as far as money going to local communities, it's all in our budget based on how we plan to do the work. It comes from the decommissioning budget. And if there is money for the communities allocated, that would have been paid. But it's all based on the project plan. When each activity occurs, when a particular milestone occurs, then a particular expense disappears. This is all detailed accounting. I cannot tell you what we were paying then and what we are paying now, if we're paying at all. It's all based on the safety regulations that NRC has in place, and we follow them, including making payments to the communities. I can't tell you any more than that because I really don't know.
So Mr. Scofield, does creating or authorizing emergency planning exemptions while nuclear waste is still cooling in the pool create an unfunded mandate for communities when the risks and response requirements haven't changed in communities near the plant since the fuel is still cooling?
Perfect. So, and so was your characterization, Senator. I think your characterization was perfect. That's how we view this situation as well. The NRC's position is that it can eliminate the emergency planning requirements that are in place to make sure that communities are prepared for an emergency. But they expect them to be able to perform without them being in place.
Yeah,
It doesn't work that way.
Thank you. I agree with you. It does not, and it's obvious, and we just have to make sure the NRC reflects that in their rulemaking. Mr. Scofield, Mr. Fettis, we heard from Director Lobinski a little bit more about what the proposed decommissioning rule would do and what it would fail to do to protect public involvement in the planning process around nuclear decommissioning. Nuclear plant operators have to submit a plan for their decommissioning activities, but under the current rule and the proposed new one, the NRC doesn't verify the substance of those plans, approve those plans, or give the public a chance to weigh in. Mr. Fettis, would you agree that the proposed rule cuts out community engagement from the decommissioning process?
Yes.
Senator Moran, would you agree that the NRC's decommissioning process would have felt more legitimate to elected officials, community leaders, and concerned residents if they were able to comment and receive a response from the Nuclear Regulatory Commission at the beginning of the process?
Very much so, and I agree, and I beseech the NRC to not make this a rubber stamp process, to not listen to the community and file it away like the books behind you in this old courtroom, Senator. In addition to the new proposed rules, let's use this process to hear from the community and to make effective rule changes that will make a better process going forward and not have, frankly, corporate arrogance dismiss community concerns as overwrought.
So thank you. I agree with you, Senator. Mr. Scofield, how would you compare the NRC's process around planning decommissioning activities to the activities that other agencies undertake for cleanup projects like EPA, its Superfund process, et cetera?
Remarkable. It's a really apples and oranges comparisons. For those of you in the room who are familiar with the cleanup process under the Superfund statute, these are major contaminated properties, industrial sites across the country that are listed on the national priority list. The EPA oversees that process. And the differences between the EPA process under CERCLA and the process that the NRC has engaged in under, not engaged in under its rules they're two different worlds. EPA is directly involved in every decision about the cleanup of those properties, whereas the NRC has a completely hands-off approach.
And I know why Superfund is different. I was on the committee in 1980 and 81 when we drafted Superfund. So I know why. The NRC got its authorization just 2 years before I got elected to Congress. So, so we're going to try to rectify, that level of full accountability. And Mr. Fettis, if the NRC could make one change to its proposed decommissioning rule to better involve communities and integrate their comments into the process, what would it be?
The ability to approve, disapprove, alter, modify, or change the decommissioning plan, have hearing rights associated with it, and supplemental NEPA review, period.
Yes.
That would change everything.
Yeah, bringing people in from the get-go is the whole key to building the confidence
Correct.
in the entire set of decisions that are going to be made for every single nuclear power plant in America. My father always said to me, Eddie, try to start out where you're going to be forced to wind up anyway, because it's prettier that way. And that's all we're really saying here. Let's put a process in place that doesn't necessarily elicit this level of public skepticism, because it's been transparent that we don't need an attorney general to intervene to get these questions answered. So I don't know if you want to come back to Congressman Keating. So just one final question for you, Dr. Singh, and then what I'm going to do is ask each of you to give us your final 1 minute, what you want us to remember from this hearing. But Dr. Singh, would you commit to meeting with the town of Plymouth to negotiate a payment in lieu of taxes agreement to compensate for lost revenue for the town?
Well, unfortunately, I cannot answer the question because I really don't know what the state of agreement is. But we always work with local townships everywhere. We try to maintain a cordial, mutually supportive relationship. We want to be a good neighbor to the township, to the plant. I will ask our president of HDI to engage with them if there is no settlement yet, to do it in the spirit of goodwill. And I should tell you that for example, keeping the water in the plant, it can be. I said that we will listen to the stakeholders, and we will. But there is a downside to it. The downside is that the facilities would not be dismantled as soon as we could dismantle them. We could discharge the water. If that's okay, we will leave it stand. After all, we have 60 years to finish. There is no such thing as free lunch in life, as you know. You make a decision, it has consequences. Like I heard, you want there is a proposal here to put in communities in consultation and approval process in decommissioning plan. Well, if you do that, the result would be that nothing will get decommissioned in anywhere less than 60 years. People would not want to bother with the business. I mean, after all, I have the choice not to be decommissioned. So let's make sure that the laws are reasonable, they serve the ultimate goal of protecting public health and safety, and not go overboard where companies, right now there is a scarcity of companies who want to decommission. You know, there's not that many companies that are willing to step up and do it. And if we make rules more onerous and we put more processes in place that basically make the decommissioning more expensive, it's going to have the effect of these plants hanging around a long time. And that, I don't think we want that. We want to, our goal, we really are focused on making sure that the township gets an excellent tax base because we get the plants decommissioned as rapidly as possible, as safely as possible, of course. And as long as we all understand that's our shared goal, we will do fine.
So we'll let that be your closing statement, Dr. Singh, and we'll give you, Senator Moran, we'll give you a closing 1 minute, and then we'll go to Mr. Fettis, and we'll let Mr. Scofield have the final word.
Thank you, Senator Markey, and to the committee. The takeaway here is I heard Holtec say they will not dump into Cape Cod Bay. I think we take that and confirm it and write it up and take him at his word. We have it right here today, and that has been the benefit of this field hearing. And thank you very much for that. And in the meantime, I think the communities have to be supported in terms of emergency funding. And those are the two issues and my request for the takeaway here today. This has been incredibly productive.
Okay, beautiful. Mr. Fettis.
I deeply appreciate the opportunity to be here. My takeaways from this hearing are the entirety of this hearing record, and especially the verbal interchange, should be put into the NRC's rule record or the administrative record for the draft rule, because it will provide clarity on the need for meaningful agency oversight, the need for meaningful agency oversight on ensuring that financial resources are there, emergency planning resources are there, and the clarity of where problems can be avoided for the future. On the issue of nuclear waste, I really want to stress to the people of Plymouth hearing today that your delegation, especially with Senator Markey's Nuclear Waste Task Force bill, is actually doing something more constructive and thoughtful than has been done in decades in Washington, D.C., by actually trying to get to figuring out how we get consent and can go forward with getting to nuclear waste repositories rather than simply trying to bully a state into taking the entirety of the nation's nuclear waste. It's never going to work. Let's do something thoughtful and constructive. So thank you.
Great, thank you. Mrs. Scofield.
Thank you, Senator Markey and Representative Keating, again, for inviting me here today and for holding this incredibly important hearing. I'll just very quickly say that I think the NRC should withdraw the rule and issue a new draft rule that's consistent with the views Commissioner Barron expressed in his dissent and consistent with those that states have consistently expressed to the NRC for years. Thank you.
Thank you, and I thank each of you for your testimony, and we will be bringing that message back to Washington, D.C. Let me recognize Congressman Keating.
Well, I want to thank you, Mr. Chairman, for having this hearing. There's much that came from it. Importantly, I hope, looking at the rule again, from a national perspective that's there, I want to thank the commitment from Holtec for moving expeditiously and responding to the EPA. I want to thank them, too, for getting an estimate of what the trucking alternative would be and committing to that. And most importantly, and I can only speak for myself, I'm coming away from this hearing, Mr. Chairman, saying there will not be 1 million gallons of radioactive water dropped in Cape Cod. I think we can say with a commitment that one of the alternatives in vaporization, if we want that, instead of dumping it there, it's okay. So as far as I'm concerned, we're not dumping any water, radioactive water in Cape Cod. And I want to thank Mr. Singh for his commitment to doing that.
So I think, well, I'm going to give you, Mr. Singh, I'll give you one final concluding statement if you'd like to make it,
Thank you,
please.
Senator. I truly appreciate it. Look, I'm not used to verbal acrobatics.
Excuse me?
I said I'm not used to verbal acrobatics. I said we will not dump contaminated water anywhere. I also said that the water is not contaminated by its definition. But we will not discharge any water in the Cape Cod Bay unless we have major stakeholder concurrence. We will not do that. I also said that that will mean that the dismantling of the facility may be delayed. And there are always pros and cons. And if the learned opinion, scientific opinion that Senator, you have so kindly agreed to organize, offered to organize, if that holds that indeed the water is contaminated and there should be a restriction on the discharge, then I would presume you can be sure we will not discharge. But if the opinion is otherwise, I hope that the community, the stakeholders will reconsider, so we do the right thing for Plymouth, not go by empirical concerns that may not exist in reality.
Okay. So thank you, Dr. Singh. And while there is no denying that our community has had to deal with several contentious issues with regard to Holtec during Pilgrim's decommissioning process, I can acknowledge that they've never before fully decommissioned a nuclear power plant. And it's possible these problems may be more of a reflection of its inexperience and not arrogance, that they don't know what they're doing. And sadly, the Nuclear Regulatory Commission has no such defense. The Commission's proposed decommissioning rule shows it to be a captured agency without improvements. I fear that this shows thus far no interest in engaging the public, which would provide even a semblance of accountability. And without a stronger regulator, I fear that the only thing that will be emptier than the decommissioning trust fund will be the public's trust in our government. We need to ensure that, that we have a new rule that we put on the books that has full public participation, full accountability for the companies that are given the responsibility for decommissioning these plants, and that it be transparent, and that we do this during the Biden era at the Nuclear Regulatory Commission. That is the least that we owe to a city, a town like Plymouth that was the pioneer in allowing for a nuclear power plant to be constructed in its community. A lot of promises were made, and those promises must be kept. It was told that it was cheap, that it was safe, that it would not pose any risks whatsoever to the community. We have to make sure that all of those promises are made. We're looking back now 50 years, and we don't want these promises to be unfulfilled for another 50. That is why we had this hearing here today, and that is why we are going to stay on this case, because this is where it all begins. This decommissioning, this set of rules that the NRC is right now considering. So before we adjourn, I would like to ask unanimous consent to submit for the record a variety of materials and include letters and testimonies from stakeholders and other materials that relate to today's hearing without objection so ordered. Senators will be allowed to submit written questions for the record through the close of business on Friday, May 20th. We will compile those questions, send them to our witnesses, who we will ask to reply by Friday, June 3rd. We have just had, I think, an historic hearing. I'm grateful for the discussion. I'm grateful for the commitments that we've received today. We need a restoration of trust so that we improve the rule and improve community engagement. That is the minimum that we need in order to move forward with confidence for the public trust in our country. We thank each and every one of you for being here today. I thank Congressman Keating for all of his great work on this issue. With that, this hearing is adjourned.